ಇಲ್ಲ ಬರ್ತಾರೆ मैडम प्रेसिडेंट मंजू के हाथ में स्लिप दिया तो बाद में लोगों को मांगा पीसीआर भी है उसमें।
Court officer, there is no audio and video.
ಸರ್ ಒಂದ್ ನಿಮಿಷ ಈಗ ಬಂದ್ರು ಮೇಡಮ್.
ಹಾ
ಹಾ ಬರ್ತಾ ಇದೆಯಲ್ವಾ ಸರ್ ಈಗ?
ಬರ್ತದೆ.
Memo, my lords. Matter is of 2021-9/22, my lords, for final hearing. My lords.
If there is urgency, we cannot take.
Insurance company appeal, my lords. 2014 matter, fresh matter, my lords, seeking for stay, my lords.
For admission.
Which year matter?
Here. Appellant. 2024.
Yes.
First matter.
Yes, my lord.
Matter for withdraw the appeal. Withdraw the appeal.
Yes.
My lords, appeal by insurance company challenging quantum and liability, my lords.
Why?
For
What
stay,
is
my
that?
lords. For stay, my lords. Fresh matter.
Insurance company appeal, my lord. Insurance company appeal, my lord. Stay.
What is urgency?
They are threatening to.
Yes, yes.
My lords, kindly next week, my lords.
No, ma. Let him come in the regular. We cannot.
Climate's appeal, my lords.
Adjournments.
Fact, no. Yes.
Adjournments page wise from admission. Page 8. 31 and 32.
Sorry, memo, fresh matter, my lord.
Yes, yes.
Page 9, 33 to 38.
34 ಮೇಲೆ 34
34, yes.
ಆ ಕೈಲಿ ರೆಫರ್ ಟು ಲೋಕಲ್
ಜೋರಾಗಿ ಹೇಳಿ ಸರ್.
ಅಪಲೆಂಟ್
ಜೋರಾಗಿ ಹೇಳಿ.
Three.
ಮೈಕಲ್
Yeah, B for appellant seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
serial number 37 मिला aim for the
30.
appellant मिला
Yes.
kindly refer to local in this matter मिला
Sri KV Naik for appellant seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
Page 10, 39 to 41.
Serial number 40 may not.
serial number
43.
Matter may be referred to local.
Huh?
Serial number 40,
40.
matter may be referred to local, connected, settle agide.
Giri Malaya for appellant seeks to refer the matter to Lok Adalat.
Serial
Hence,
number
the matter is
33,
referred
madam.
to Lok Adalat for settlement.
serial number 33 maybe
30.
referred back to refer to local serial number
33.
33 maybe refer to local
Sri Sanat Kumar KM for appellant seeks to refer the matter to this matter.
Page 10, page 11, 42 to 46.
My lord, serial number 40. My lord, 45, my lord. Serial number 45. My lord, serial number 45, my lord. My name may be deleted, my lord. Mr. Pradeep has filed wakalat.
Yes, we'll see when the matter is called. Yes.
Please, my lord.
Page 12, 47 and 48.
My lord, serial number 48, my lord.
Yes.
In this case, there is another connected matter, that is 459/23. And Shivarna Gowda has to file the wakalat also.
today we are going to file wakalat
Sri Sripad V. Shastri, who
Yes, sir.
appears as appellant in all the three matters, submits that MFA 459 of 2023 is also collected to the present set of appeals. Seeks to list the said appeal also on the same day along with these appeals. Therefore, register to verify and to list these appeals along with MFA 459 of 2023. 23. Full stop. Sri B.C. Shivanna Gowda has not filed wakalat for respondent number 2 in all the three matters. Seeks time. A week time is granted. List on 21st October.
Much.
My lord, page 13,
Serial
49
number
and
61, my lord. Nilapa.
wait, sir. Page 14, 51 to 57.
My lord, serial number
51.
Yes,
ಸ್ವಲ್ಪ wait ಮಾಡಿ sir.
51, my lord. I appeal for second respondent. So far,
I
I have not received the vocal. 1 week time.
my
I am
lord,
appellant, my lord.
Sripad Shastri.
Mr. Counsel, you
Yes.
were directed to file wakalat on 16/8
Yes,
2023,
yes,
1
ma'am.
year. We can't go on granting.
Next week, without fail, I informed Sripad Shastri also.
Yes, yes, I inform.
Sri C. Shankar Reddy seeks time to file wakalat for respondent number 2. Full stop. The record discloses grant of time more than a year to file wakalat. Full stop. However, to give fair opportunity, time for a week is granted to file wakalat. Full stop. In case respondent number 2 does not take steps for entrusting the matter to any advocate within the time granted, the second respondent would be at liability to pay costs of ₹2,000 to High Court Advocates Library Fund. List on 1st October.
Much.
My lord, serial number 50, my lords.
50
Is appearing for the appellates, my lords. The matter may be kindly referred to Lok Adalat, my lords.
Your good name, Mama?
Payal.
Huh?
Payal.
Payal.
Miss Payal, representing Sri Pavan Chandra Shetty, Land Council on record for the appellant, seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
My lord, serial number 52, my lord.
Yes,
My lord, the judgment is in Kannada and records is also necessary if they dismiss a claim petition. That is why records may be called for, my lord.
have you informed the other side?
Yes,
Mr.
yes, 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 yes. Dabali, I inform.
Third, Sripad V. Shastri, Land Council for the appellant. Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on 28th October.
47 serial number. Rangegoda objection.
Huh.
47 and 2 weeks.
For what purpose, Mr. Counsel?
Out of case. Opponent counsel.
Sri Ravi Shankar, representing Sri Rangegoda NR, Land Council for the appellant in both the matters, seeks time. Hence, stand over.
Milords.
30th September, 30.
Already
Milords, serial number 7, Milords.
Sir,
My
wait
lord,
ಮಾಡಿ
serial
call
number
ಮಾಡ್ತೀವಿ.
54, my lord.
Next.
Serial number 54.
Yes, Mr. Counsel.
Lord, I am for the appellant, my lord. This matter is connected with MFA 8599/23 filed by the claimant.
Sri D. Vijay Kumar for appellant appears through VC and submits that the present appeal is connected to
8599/23.
Full stop. In the light of the submission thus made, register to verify and to list the present matter along with MFA so and so on 30th September.
Much obliged.
Next.
Page 15, 58 to 62.
Number 58, my lord. I'm appealing for the respondent 1 and 2. The claimants also file an appeal in MFA number 1897 of 24.
Sri Sanat
Nimsha
Kumar
Tolma.
KM for respondent number 1 submits that MFA so and so
1897 of
to
2020.
the present appeal.
18.
To list both the appeals on the same day.
My lord,
In the light of the submission thus made,
897.
registry to verify and to list the present appeal along with MFA so and so on
ಚೀಟಿ ಕೊಟ್ಟುಬಿಡಿ ಅವ್ರಿಗೆ.
14th October.
58.
Serial number 60, my lord.
Yes,
Can the matter may be referred to Lok Adalat?
14th October.
Sri Kailash Shankar PS for appellant seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
One submission, serial number
Serial number
62.
61.
Page, wait, sir. Page 16,
61,
63
my
to
lord.
67.
Serial number 63, man.
Yes.
61, my lord.
Next time.
Serial number
14,
61.
1410.
Three G.S. Marulaya,
My lord, so meanwhile, the matter may be kindly referred to Lok Adalat, my lords.
58.
I'll file the wakalat.
Ms. Payal representing Sri Pavanachandra Shetty, heads Land Council on record for the appellant seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
Week's time to file.
Yes. A week's time is granted to Sri.
My lord,
G.S.
serial number 61.
for respondent. Next. Next.
Serial
Sir,
number
ಹೇಳಿ.
61, my lord.
61.
Serial number
Yes.
61, my lord, after 10 days, my lord. I was out of station. I am out of station.
You have not filed wakalat, Mr. Counsel?
My lord, I will comply with by that time, my lord.
You have not filed your wakalat till now, since 22/9/2023. Since
I will
1
file
year.
it, my lord. I will file it.
Sri S.V. Hegde.
10 days time may kindly be given. I will take one more copy from Ravi Shankar Shastri.
And seeks time to file wakalat. Full stop. As per office note, comma, time for about 1 year is granted for respondent number 2 to engage a counsel. Full stop. However, to give fair opportunity, a week time is granted to Sri S.V. Hegde Mulkund to file.
10 days, my lord. 10 days, my lord. I am out of station.
A time for 2 weeks, 2 weeks is granted. In case wakalat
Yes,
is
ma'am.
not filed within the time granted, the respondent number 2 would be at liability to pay cost of ₹2,000 to High Court Advocates Liability list on 16th October.
One submission, serial number 62. I appear for the appellant in the connected matter. Mr. K. Shantaraj, who appears in the for appellant in the connected matter, he is unwell. Kindly a week's time may be granted,
Sri Anup Sitaramara appears through VC and submits that his counterpart, Sri Shantaraj K, is unwell.
Have you read the objection?
In the light of the
Have you read the
submission
objection?
made,
What is
list
the
both the
objection?
matters on 21st October.
Much obliged. Page 16, 63 to 67.
My lord, serial number 67, my lord. This matter I pay for appellant, my lord. Yes, my lord. Week time, my lord.
Why?
My lord, today inconvenience.
Next.
Page 17, 68 to 70.
Lord, serial number 17. Next time, next week, file the
Kindly
wakalat.
refer to Lokath, my lord. I am for the appellant, my lord. Serial number 70, my lord.
Of Sri K.V. Naik, the matter is referred to Lok Adalat for settlement. Full stop. A week time is granted to Sri K. Nagarajaya to file wakalat for respondent.
Much of it.
Order serial number 1. Vishwanath Pujari. R2 served unrepresented.
My lord, I filed memo for dispensation R1
Why it has to be dispensed with?
because his liability is admitted by the insurance company and he deposited. He satisfied. United Company served, my lord.
Memo seeking dispensation of notice upon respondent number 1 is on record. Full stop. Third is Sri Vishwanath Pujari, Land Council for the appellant. Full stop. Land Council states that as the respondent number 2 admitted its liability, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Next.
Matter may be referred to Lok Adalat.
No one is appearing for respondents.
No, United India is a company. but it will be settled in the Lok Adalat.
But there is no representation.
Yes.
With whom you will settle?
Company will come to the Lok Adalat and they will settle.
Sri G.S. Marulaya is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Next, at the request of Sri Vishwanath Pujari, Kale and counsel for the appellant, the matter is referred to Lok Adalat for settlement.
Serial number 2, VP Radha.
For the appellant, my lord. Memo has been filed on 3rd September to dispense of with notice to respondent number 2. Respondent number 2 is arraigned as respondent number 3 in the connected appeal. A notice was served to him, but he failed to appear before the court, my lord. And the same notice was held to be sufficient in that matter. The same may be held as sufficient in this matter also.
How can it be? How can it be? If that appeal is dismissed, this appeal should also be dismissed. Your good name.
Anusha Raj, my lord.
Heard, Miss Anusha Raj, who represents Srimati B.P. Radha, Land Council on record for the appellants. Full stop. Memo seeking dispensation of notice upon respondent number 2 is on record. Full stop. Miss Anusha.
Anusha Raj.
Anusha, for appellant submits that as submits that respondent number 2 in this appeal is arraigned as respondent number 3 in the connected appeal. Full stop. In the connected appeal, though notice was served upon respondent number 3, he did not turn up, and therefore notice to respondent number 2, who is the same party, in MFS 2790 of 2022 should be held sufficient. Full stop. Memo, the contents of memo also discloses the same contention. Full stop. Service of notice, next paragraph. Service of notice in one matter cannot be held to be service of notice in another matter. Full stop. Law requires issuance of notice to the contesting parties in all the matters separately. Full stop. Therefore, the memo is rejected. Full stop. Issue notice to respondent number 2. Appellants to furnish the requisites. List the present matter along with connected matter, that is MFA 5787 of 2022 on 11th November.
11th November. Serial number 3.
Lord,
Prakash.
representing respondent number 2 and 3, my lord.
For the appellant, Arun is the driver of the vehicle.
Week
my
time
lord.
press, my lord. Memo of appearance filing, my lord. AGA, my lord. Manjunath Rayappa, AGA.
Why the notice has to be dispensed with?
He is the owner of the driver, driver of the
Liability-
vehicle, my lord.
2 and
The
3.
vehicle belongs to the government. And liability fixed against the 2 and 3, my lord.
Memo seeking dispensation of notice upon respondent number 1 is on record. Heard, Sri Prakasha HC, Learned Counsel for the appellant. Full stop. Learned Counsel for the appellant submits that as the liability was fixed upon respondents 2 and 3, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submissions as made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Next paragraph.
AG Manjunath Virayappa,
Sri
AGM, my lord.
Manjunath
Manjunath Rayappa, my lord.
V. Rayappa,
Additional government.
learned AGA, Assistant Government Pleader, seeks time to enter into memo of appearance for respondents 2 and 3. Full stop. Time for 2 weeks is granted. List on 14th October.
Regarding delay, my lord, will not claim any interest, man.
Let them.
Please. Complain.
Serial number 4, Sripad V. Shastri, B.
My lord,
Pradeep for R2.
I am for appellant, my lord. I Climant's appeal. There is no liability on R1. Insurance company admitted the liability. My lord,
Sri Sripad V. Shastri, Land Counsel for the appellant who appears through VC. Full stop. Memo seeking dispensation of notice upon respondent number 1 is on record. Full stop. Land Counsel Sri Sripad V. Shastri submits that as a respondent number 2 admitted its liability, comma, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
my lord, this appeal is connected with 3411/22.
Land Counsel Sri Sripad V. Shastri submits that the present appeal is connected with MFA so and so.
Answer number
3411/22.
22.
List the present, hence register to verify and to list the present matter along with MFA so and so on 4th November.
Meanwhile, call for TCR, my lord. Required TCR.
The records from the concerned tribunal in the meantime.
Please, my lord. Much obliged.
4th November. Serial number 5, Shankar C. Reddy, Mahesh Kiran Shetty. Serial number 5, C. Shankar Reddy.
No representation on appellant side on call. As per office endorsement, some objections are not complied yet. Time for a week is granted to comply the office objections. On complying the office objections, office is directed to do the needful. List on 5th November.
Serial number 6,
My lord, I am for the respondent 1 to 4, my lords.
Mangala Swami, Harish Yanna.
Yes.
Say for a week time to file a memo regarding the deposit of amounts deposited.
I press upon the IA 1 of 24, my lords, to withdraw the amount. The amount has been deposited, it seems, but
Deposited. So any objection for?
No. ಹಾಕಿದ್ದಾರೆ memo.
IA 1 of 2024 is filed. By the claimants, that is respondents 1 to 4 to the appeal, seeking permission to withdraw their respective shares out of the deposited amount. Next, third, Sri
Shreyas and my lords.
Land Council who represents Sri Harisha NR. For the petitioners as well as Srimati Sumangala A. Swami, Land Council who represents Respondent oblique Appellant. Good stop. Land Council Sri Shreya submits that the Respondent deposited 50% of the award amount as per the directions of this court. Through orders dated 9/2/2020. And therefore permission may be accorded to the petitioner's claimants to withdraw their respective shares. Full stop. Srimati Sumangala A. Swami did not raise any objection for according the permission as sought for. Full stop. Also, the request made is justifiable. Full stop. Therefore, the petition is honored. The petitioners oblique claimants are permitted to withdraw their respective shares out of the deposited amount, subject to the conditions, if any, imposed by the tribunal through the impugned order. Next. Admit. Call for the records from the consent tribunal. List the matter under the caption final hearing on 110. Memo of retirement filed by Sri G. Shankar Gaut is accepted.
Serial number 7.
Grateful. Deeply obliged, my lord.
I am for the appellant in this case, my lords. I had filed an application, I had filed a member for dispensation in this case for R1, my lords.
Why it has to be dispensed with?
Yeah, in this case, my lords, only wakalat was filed and they had not represented it in the lower court, my lords. And the liability is also on the insurance company, my lords.
Memo seeking dispensation of notice upon respondent number 1 is on record. Third, Sri. You are Mr. Chetan Lathur?
Ketan Lathur, madam.
Sri Ketan Lathur, Land Council who represents Sri Lathur Suresh Mahalingappa, Land Council on record for the appellant. Full stop. Land Council submits that respondent number 1 did not contest the matter before the tribunal, and that apart, liability is fixed upon respondent number 2, and therefore notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
And my lords, kindly issue notice to R2, my lords, in this case.
Bharati asks a gentleman. Any standing counsel? Yes. Sri B. Pradeep is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri B. Pradeep. List on 4th November.
Serial number 8. Pavan Chandra Shetty. Ravish Benny for R2.
My lords, we have already filed the dispensation memo, my lords.
Why notice has to be dispensed with them now?
My lords, the liability is fixed on the insurance company, my lords. That's R2 and R5, R4, my lords.
Third,
File.
Miss Payal, who represents the Pavan Chandra Shetty H. Land Council on record for the appellant. Full stop. Memo file. Memo seeking dispensation of notice upon respondents 1 and 5 is on record. Full stop. Miss Payal submits that as liability is fixed only upon respondents 2 and 4, comma, notice to respondents 1 and 5 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondents 1 and 5 is dispensed with, however, at the risk of the appellant. Full stop. 3, next parama. Sri Ravish Benny is on record for respondent number 2. Hence, office is directed not to show the name of Sri Janardhan Reddy in the cast list. Full stop. Sri P.B. Raju has not filed wakalat for respondent number 4. Full stop. No representation for respondent number 4. Full stop. On 17/11/2023, Sri P.B. Raju was called upon to take note to accept notice for respondent number 4 and file wakalat. Full stop. However, Sri P.B. Raju has not filed wakalat yet. Full stop. Hence, issue notice to respondent number 4 on furnishing the requisites. List on 11th November.
Much obliged, my lords.
Serial number 9, Tanuja MV.
Happy for the appellant, my lord. My lords, respondent number 1, 2 and 1, 2, 4, 5 are not made as parties because the claim petition was dismissed against all of them, my lords. That was the office objection raised by the office, and I have made the statutory deposit also on 23/8, my lords. Now, my lords, the involved vehicle is two-wheeler and a tractor. I am the owner of the tractor. And the contention of the learned trial judges that there was rash and negligent driving by the driver. So I made liable for paying the compensation. As there was no insurance, I was made liable, my lords. My lords, I have this PW1 has not tendered fully for cross-examination.
Now you have to make them as parties to the appeal, and again you can seek for dispensation of notice upon them. But you cannot totally take out.
My lords, against all of those respondents, the claim petition was.
Third, Miss Tanuja, MB.
My lords, now the respondent has filed for, I'll make the application meanwhile, my lords, and it is on 20th/9. Kindly stay may be granted so that meanwhile I'll make a date may be given.
Council is granted time for 2 weeks to comply the office objection.
My lords, it's on 20th/9, my lords.
List on.
Next week, any date may be given, my lords.
Why it should be, Amma? You filed in the month of July 2020.
My lords, I underwent heart surgery in my part full became, so I am not able to move.
Subjections, hence list on 23rd September.
My lords, the case was on 20th of September. Execution, they have filed execution 8/28 of
19th September.
much. Okay.
Office objections comply, madam.
Right.
Serial number 10. Suma K.
My lord, I am for the respondent, my lord. In this case, my lord, recently I have received the copy of the appeal memo with the repeated request. I have sent it to KSRTC. My lord, shortly I am going to get the wakalat and file it. Kindly grant 2 weeks time.
Land counsel Sri D. Vijay Kumar appears through VC and seeks time to file vakalat. Full stop. Time for 2 weeks as prayer is granted. List on 15th October.
Much obliged.
Serial number 11. Sanat Kumar KM. Hearing on a SV Hegde for.
Should I appear for the respondent, my lord?
Appellant. Climate's appeal.
Yes.
It's a delay of 148 days, my lord.
Any objection for condoning the delay?
My lord, no objection, my lord. Delay may kindly be condoned, my lord.
IA 1 of 2020.
Delay may kindly be condoned, my lord.
IA 1
Aye,
of
sir, ಕೇಳಿಸ್ತಾ ಇದೆ.
2021 is filed, seeking the court to condone the delay of
Delay may kindly be condoned.
in filing the appeal. Heard, Sri Sanat Kumar KM, Land Counsel for the appellant, who appears physically before the court. Full stop. Also heard, Sri SV Hegde Mulkun, Land Counsel for respondent number 2, who appears through VC. Full stop. Land Counsel Sri SV Hegde Mulkun states that he has no objection whatsoever to condone the delay. Full stop. In the light of the submission thus made, the delay as prayed for is condoned.
Severe head injury, my lord. The LCR has to be called.
Admit, call for the records from the consent tribunal, list the matter under the caption final hearing on 21st October.
My lord, Janardhan Reddy's name may kindly be deleted. Janardhan Reddy had not filed wakalat. His name may kindly be deleted.
Sorry, sir.
On record for respondent number 2, office is directed not to show the name of Sri Janardhan Reddy in the cause list hereafter. Yes.
Serial number 12. MV Maheshwarappa.
Appear for
Ravi Shankar.
appellant,
Appear for respondent.
208 days delay for filing the appeal, case of injuries, your lords.
Delay may be condoned. It cannot be entitled for interest for the delay.
IA 1 of 2021 is filed, seeking the court to condone the delay of 208 days in preparing the appeal. Heard, Sri MV Maheshwarappa, Land Counsel for the petitioner appellant, as well as
HC Lokeshwari. HC Lokeshwari.
Ms. HC Lokeshwari, Land Counsel who represents Sri A. Ravi Shankar, Land Counsel on record for respondent number 2. Full stop. Gone through the contents of the affidavit given in support of the petition. Full stop. Having regard to the ground searched, which remains unopposed, the delay as prayed for is condoned. Full stop. However, the appellant will not be entitled for any interest over and above the amount which is awarded by the tribunal, if any awarded by this court through the judgment in the appeal for the period of delay of 208 days. Yes.
I am ready.
Yes.
Ready, madam.
Next time. I will argue next time. Judgment copy is not there.
Admit, list the matter under the caption final hearing on 17th September.
Obliged.
Serial number 13. K. Prasanna Shetty. R2 served under present. Serial number 13. Prasanna Shetty.
For the appellants, my lord. My lord, there is a delay of 280 days, my lord. The reason being, my lord, the award was passed in March 2019, my lord.
There is the service of notice.
Date केले madam और क्या?
My lords.
1 minute.
R2 served.
Yes, yes.
Yes, my lords. The delay is, my lords, there is a delay of 280 days, my lords. The reason being, the award was passed in their March 2019, my lord. The COVID situation and, my lord, the appellant stays in a remote village area, my lord. So he could not afford to come to Bangalore to file, my lord. So kindly condone the delay, my lord.
IA 1 of 2023 is filed seeking the court to condone the delay of 280 days in preferring the appeal. Heard, your good name.
Bharat Pujari, my lord,
Heard, Sri Bharat Pujari,
for Prasanna Shetty.
who represents Sri K. Prasanna Shetty, Land Council on record for the appellant. Full stop. Land Council states that the petitioner appellant resides in a remote village and in the circumstances prevailing due to COVID, he could not move his village, contact his advocate and prefer appeal within time, and therefore the delay as prayed for may be controlled. Having considered the submission thus made, and upon going through the contents of the affidavit given in support of the petition, the delay as prayed for is controlled. Yes.
Notice may be served, my lord.
Notice already served, no, there is no representation.
No representation.
Admit, list the matter under the caption final hearing on 18th September.
Yes, my lord.
When they have not chosen, what can we do?
Serial number 14, Jagan Mohan, MT. HC Bedsore.
Just now I received the copy. I'll file wakalat.
You have already filed wakalat, Mr.
No, just now he has served the copy on me, appeal memo. Now I received.
Name
I was directed to take notice in this.
You see whether wakalat is paid. Three HC Bedsure submits that he has not filed wakalat yet. Full stop. Seeks time. Full stop. Time for 2 weeks is granted. List on
Copy served. Copy now served.
23rd September.
Serial number 15, Nagaraj Reddy.
For the appellant.
SN Manjunath for R.
For respondent number 1,
Appeal was dismissed for non-prosecution. Sought recalling of the document. This delay. The appeal was dismissed for non-prosecution, lords, and sought for recalling of that order. There is delay of 40 days also in filing the application.
You have not filed your wakalat?
I have not filed wakalat, my lord. Just week's time, my lord, I will file wakalat. Respondent number 1.
You were directed to take notice on 15/2/2022.
Please, my lord.
After 2.5 years, how casually you ask a week time, Mr. Counsel?
Finally, press week's time, my lord, I will file wakalat.
Sri Mallikarjun Reddy, representing Sri Pradeep B, seeks time to file wakalat for respondent number 1. Full stop. On 15/2/2022, Sri B Pradeep was directed to take notice for respondent number 1. Full stop. However, wakalat is not filed till now. Full stop. Without assigning any reason whatsoever, time is sought very casually for filing wakalat. Full stop. However, to give fair opportunity, time for a week is granted to file wakalat. Full stop. However, respondent number 1 would be permitted to pursue the matter, would be permitted to contest the matter only on payment of cost of rupees 5,000 to the High Court Advocates Library Fund. Full stop. List on 30th September.
That's one submission, madam. 5,000 is higher, sir, madam.
About 2.5 years.
Finally, weeks time, madam, so I will file wakalat, madam.
Next.
Serial number. Serial number 16, Gurudev Prasad KT. Serial number 17.
That I am for respondent claimant. I made this application,
See,
but
but so-
my appeal is also there, my lord, 3959/23. My lord, it may be called along with this my appeal, 3959/23.
Sri Shripad V. Shastri, Land Counsel for Respondent number 1, appears through VC and submits that MFA so-and-so is connected to the present appeal. Seeks to list both the matters on the same day. Full stop. In the light of the submission thus made, registered to verify and to list the present appeal along with the MFA so-and-so on 15th October.
Sir, MFA number
3959/23.
3959/23.
23.
And also records may be called for in this.
At request of Sri H.C. Bensur, Land Counsel for the appellant, call for the records from the consent decree.
Serial number 18, A.N. Krishnaswamy. Ravi Kumar NR for respondents.
Respondent claimant. And filed the application for the amount deposited by the insurance company to release the amount, my lord. Only quantum they have challenged, not liability, my lord.
Amount could. Lord, he has filed an appeal that also connect. He has filed an appeal that also could be connected.
IA 1 of 2024 file seeking the court to permit the petitioners oblique claimants to withdraw their respective shares out of the deposited amount. Now, IA 1 of 2024 is filed seeking the court to permit the petitioners oblique claimants 1 and 4. Claimants 1 and 4 to withdraw their respective shares out of the deposited amount. Heard. Sri Ravi Kumar NR, Land Counsel for the petitioners oblique claimants 1 and 4, and also Sri A.N. Krishnaswamy, Land Counsel for Respondent Insurance Company.
2 and 3 are minor children of the first.
Next period. Land Counsel Sri Ravi Kumar NR submits that challenging the quantum that is awarded as compensation, the insurance company preferred appeal, and therefore the deposited amount may be released in favor of the petitioners. Sri N. Krishnaswamy, who represents the insurance company, did not raise any objection for according such a permission. Also, the request made is justified. Therefore, the petition is allowed. The petitioners oblique respondents 1 and 4. The petitioners oblique claimants 1 and 4 are permitted to withdraw their respective shares out of the deposited amount, subject to the conditions, if any, imposed upon them by the tribunal through the impugned order. Next. Sri A. Krishnaswamy submits that MFA so-and-so is connected to the present appeal, seeks to list both the appeals on the same day. Full stop. In the light of the submitted first made,
144
comma,
0.
registry to verify and to list the present appeal along with MFA so and so on 21st October.
Serial number 19, Geeta R. Sandhya D for R1.
The respondent has filed an application seeking release of amount, have deposited 50% of that amount, out of which 50% may be released by notes.
Your good name, Mama?
Sandhya,
You are representing?
the appellant, and in the 19.1, my lords, in 19 for the respondent number 1,
Respondent.
first respondent claimant.
A3 of 2024 is filed by the petitioner claimant seeking the court to permit him to withdraw the deposited amount. Heard. And counsel for the petitioner
ಶಾಸ್ತ್ರಿಗಳ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
oblique claimant as well as Srimati Geeta R. Land Counsel for Respondent Insurance Company. Full stop. Gone through the contents of the affidavit given in support of the petition. Full stop. Srimati Geeta R. did not raise any objection to accord permission for withdrawal of the amount as sought. Full stop. Also, the request made is justifiable. Full stop. Thus, the petition is allowed. Next, the petitioner oblique claimant is permitted to withdraw the deposited amount as sought for.
And not 50% of the amount deposited.
That
The amount what have, out of the amount I have deposited, out of which 50% can be released. by notes. My lords, I have filed my appeal on 2 counts. One is, even assuming the disability as per the doctor, the disability would not exceed more than 22%, whereas the tribunal has considered 30%. And the other ground I've raised is the claimant was working as a home guard and he has continued in the service despite of it loss of future earning capacity.
He will be entitled for such amount.
Yes, the total compensation is around 18 lakhs, my
18
lords.
lakhs. You have deposited 9 lakhs.
Yes,
At least he would get that 9 lakhs.
Because the medical
My lords,
expenses,
may I
the medical expenses is around 1.5 lakhs, my lords. So even then,
My
medical
lords,
expenses is around 5 lakhs 70,000.
lakhs.
Yes, it can be.
What did you do? As sought for, without furnishing any security. Next. Admit. List the matter under the.
Kindly
caption-
TCR may be called, my lords.
Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on 11th November.
Much obliged, grateful, my lords.
List both the matters, list both the matters under the caption final hearing. In the other matter, you have to file.
I'll take.
Second one, connected man.
Vakalat.
Yes, I would file wakalat, my lords.
Next.
Serial number 20, KV Nayak.
I'm appearing for respondent number 2, my lord.
Climant appeal, my lord. 4 days delay in filing the appeal.
Objection.
IA 1 of 2024 is filed seeking the court to condone the delay of 4 days in preparing the appeal. Third is the KV Nayak, Land Counsel for the petitioner appellant, as well as your Mr. D. Manjunath,
Rahul MP.
as well as Sri Rahul MP, Land Counsel who represents Sri D. Manjunath, Land Counsel on record for respondent number 2. Instead of having regard to the ground urged, the delay as prayed for is condoned. Yes.
TCR called.
Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on
19th November.
Much obliged.
Serial number 21, KV Nayak.
I appear for a
Ravi S. Samprati.
claimant's appeal, Mila. 63 days.
First respond, Ravi Samprati. I pray for a week's time to file the wakalat. Papers have been sent to the company. Last week it is done.
Sri H.S. Lingaraj, representing Sri Ravi S. Samprati, submits that a week time may be granted to Sri Ravi S. Samprati to file wakalat for respondent number 3.
Delay may be condoned 68 days.
Time as prayed for is granted. Next one. IA 1 of 2024 is filed, seeking the court to condone the delay of 63 days in filing the appeal. Heard Sri K.V. Nayak, then counsel for the petitioner appellant, as well as Sri H.S. Lingaraj, then counsel who represents Sri Ravi S. Samprati. It's gone through the contents of the affidavit given in support of the petition. Having considered the ground urged, some of the delay as prayed for is condoned. Next. List on.
TCR called, Mila. Kindly TCR is.
Yes.
Please. Much obliged.
Yes, 5th November.
5th November. Serial number 22, Prakash H.C.
In these,
H.S. Lingaraj.
in these two cases, I appear for the respondent. I was directed to take notice on the last date of hearing. I have sent the papers last week.
Sri H.S. Lingaraj seeks time to file wakalat for R2 in both the appeals. Time for a week is granted. List on 4th November.
That's normal.
14. Serial number 23, B. Pradeep.
I am for appellant, my lord. Insurance company challenging my lordship in appeal 113 days delay my filing appeal, my lord.
Yes.
Insurance company challenging the negligence as well as quantum, my lord. Two vehicle involved in the head-on collision, my lordship. Entire negligence fixed against to the appellant, my lordship. Hence, I am challenging the negligence as well as quantum, my lord.
Yes. Heard Sri Mallikarjun Reddy, who represents Sri Pradeep B. Land Council on record for the appellant. IA 2 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Additional Motor Accident Claims Tribunal, HOLAR, in MVC 165 of 2022, dated 20/10/2023. Learned Counsel Sri Mallikarjun Reddy submits that 2 vehicles are involved in the accident and there is contributory negligence on part of the and the drivers of both the vehicles were at fault. However, the tribunal fixed entire liability against the appellant and ordered it to pay compensation. And therefore appeal is filed. Learned Counsel thereby seeks to stay the operation of the impugned award. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Thus, the execution of the award that is passed by the Additional Motor Accidents Claims Tribunal HOLAR in MVC 165 of 2022, dated 20/10/2023, shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Next, on such deposit, the registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Issue notice to the respondents in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 25th November.
Please, my lord.
Serial number 24, Harish NR.
My lords, I'm for the appellant, my lords. My lords, this is an injury case. The offending vehicle is lorry, my lords. So therefore, the respondent one, who is the driver of the vehicle, may be dispensed with, and notice may be directed to respondent two, which is HDFC.
Memo for dispensation.
Please,
Mr.
ma'am,
Counsel.
I've got it, ma'am.
Please. Heard. 3. Shreyash N. Land Council, who represents Sri Harish NR, Land Council on record for the appellant. Full stop. Land Council files memo seeking dispensation of notice upon respondent number 1. Full stop. Land Council submits that as liability is fixed upon respondent number 2, comma, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
Notice may be issued to my lords, respondent to HDFC Ergo.
Sri H.S. Lingaraju is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri H.S. Lingaraju. List on 28th October.
Deeply obliged, my lords.
Serial number 25, HS Lingaraju.
The appeal for the appeal is by the insurer challenging the liability fastened upon it. The owner admits that the driver was not having a rider of the motorcycle, and he has been charge sheeted under section 3 and 181. I am challenging the liability. I'll deposit 50.
Heard. Sri H.S. Lingaraj, Land Council for the appellant. Next, IA 2 of 2024 is filed. In the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MVC 6837 of 2022, dated 16/11/2023. Next, Land Council Sri H.S. Lingaraj submits that the insured violated the terms and conditions of the policy, and therefore the petitioner appellant is not liable to pay any compensation. However, the tribunal fixed liability upon the petitioner appellant also, and therefore he preferred an appeal. Full stop. Land Council thereby seeks to stay the operation of the impugned award. Full stop. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however proportionally. Full stop. Thus, the operation of the award that is passed by Motor Accidents Claims Tribunal, Bangalore, in MVC 6837 of 2022, dated 16/11/2023, shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Next, on such deposit, registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further notice. Issue notice to the respondents in the appeal as well as in IA 1 of 2024 and 2 of 2024 on furnishing the requisites. List on 25th November.
Much.
Serial number 26, B Pradeep.
For appellant, my lord, insurance company filed an appeal, my lord, to filing and 105 days delay in filing appeal, my lord. Insurance company challenging in quantum, my lord. Instead of 1/3 deduction, 50% has been deducted, my lordship. Is in PW1 cross examination is admitted that she has not seen the accident. But further, she was admitted that she was receiving the pension of the death of her husband, my lordship. Hence, will deposit 50%, my lord.
Third, Sri Mallikarjun Reddy, who represents the Pradeep Wheel and Council on record for the appellant. IA 2 of 2024 is filed, seeking report to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal Pandavapura in MVC 1605 of 2022 dated 6/12/2023. Mr. Plan Council states that though the first claimant is given compensatory appointment,
Sorry, my lord.
she is given employment.
No, my lord, she is getting pension, my lord.
Though the first claimant is getting pension,
In cross examination, she has admitted.
she is getting pension, the tribunal held that she is entitled for compensation. Mr. Plan Council also states that by applying the wrong multiplier,
Deduction.
Land Council also states that without deducting the exact amount which is required to be deducted towards personal and living expenses, the tribunal awarded excess sum as compensation, and therefore this appeal is filed. Mr. Plan Council thereby seeks to stay the operation of the impugned award. Mr. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Thus, the operation of the award that is passed by the Motor Accidents Claims Tribunal Pandavapura in MVC 1605 of 2022 dated 6/12/2023 shall stand state until further orders on the petitioner appellant depositing 50% of the award amount before the concerned tribunal within a period of 4 weeks. Full stop. On such deposit, the respondents claimants 1 to 3 are permitted to withdraw their respective shares without furnishing any security. Full stop. Issue notice to the respondents in the appeal as well as in IA 1 of 2024 and IA 2 of 2024 on furnishing the requisites. List on 25th November.
I am filing dispensation respond number 4, my lord. Owner of the vehicle, we are not.
Memo filed seeking dispensation of notice upon respondent number 4. Full stop. Learned Council Sri Mallikarjun Reddy submits that as no relief is claimed against respondent number 4, notice to respondent number 4 may be dispensed with. Full stop. Having considered the submission thus made, notice to respondent number 4 stands dispensed with, however, at the risk of the appellant. Thereafter, you write, issue notice to respondents 1 to 3 in the appeal as well as in IA so and so on punishment. List on so and so.
Serial number 27, D. Vijay Kumar.
My lord, I am for the appellant, my lord. Appeal is by the Bangalore Metropolitan Transport Corporation, my lord, challenging the negligence and quantum of compensation. My lord, the vehicle is not involved in the accident. It was not at the place of accident. Some other vehicle, or because of his own negligence, he might have met with an accident. And in collusion with the police, my lord, he has falsely implicated our vehicle subsequently. Therefore, my lord, our vehicle is not involved in the accident and the BMTC is not able to pay any compensation.
Third, Sri D. Vijay Kumar, D. Vijay Kumar, who appears through VC and represents the appellant. Next, IA-2 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MVC 5861 of 2018, dated 8/4/2024. Full stop. Learned Counsel Sri D. Vijay Kumar submits that the alleged offending vehicle
Is not involved in
of
that.
the petitioner appellant was not involved in the accident at all. Full stop. To gain wrongfully, comma, a false case was foisted against the driver of the said vehicle. Full stop. Learned Counsel submits that without looking into those aspects, comma, the tribunal awarded compensation and therefore an appeal is filed. Learned Counsel thereby seeks to order stay of the operation of the impugned award. Next, having considered the submission thus made, comma, this court is of the view that stay as prayed for is required to be granted, however conditionally. Full stop. Thus, the operation of the award that is passed by Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 5861 of 2018, dated 8/4/2024, shall stand state on the petitioner appellant depositing 50% of the award amount along with accrued
Before High
interest
Court, my lord.
before this court within a period of 4 weeks. Full stop. On such deposit, registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Full stop. Issue notice to the respondents in the appeal as well as in IA-1 of 2024 and 2 of 2024 on furnishing the requisites. List on 25th November.
Much obliged.
Serial number 28, B.S. Umesh.
My lord, I appear for the appellant. Insurance appeal, my lord. It is almost similar to the previous matter, my lord. False implication of the vehicle. The treatment taken is towards diabetic ulcer. It has nothing to do with the accidental injuries. There is a delay of 3 months in lodging the complaint.
Change the name as Sri P.S. Umesh. Earlier, change the name as.
Entire thing could be repeated, my lord. Records also may be called.
No. IA-1 of 2024 is filed, seeking the court to stay. Same, change the number of the case and do the same. Yes.
Grateful, my lordship.
Same date. Serial number 29 for dismissal, Prakash H.C.
For the appellant. Sorry,
I am
my
for
lord.
the respondent, my lord. I am ready for argument.
Last
with
of
the-
the date of hearing, I was not in station, my lord.
Yes.
So I intimated some colleague, but he was not represented.
Huh?
He was not represented before this.
Yes, yes.
Sorry, my
okay.
lord. This is claim of.
My lord,
regarding
para
only
58
quantum,
of
my
the
lord.
judgment, kindly see, my lord.
Only quantum, my lord.
Yes.
Para 58 of the judgment.
In page number 51, 51 mile. 49, it starts from 49. In MVC number 440 of 2015, my lord.
Relevant para is para 60. Para 60.
He was impatient in
1 minute, Mr. Khan. At page 49 of the impugned order.
yes, my lord.
Yes.
In regarding MVC number 440 of 2015, my lord.
Yes.
He was sustained injuries. First, he was admitted in Kadur Government Hospital. First, he was taken first aid treatment. Thereafter, Meghan Hospital, Shumoga, and thereafter he shifted to Nimans, Bangalore.
and he continued his treatment in St. Martha's Hospital, madam. He was hospitalized for 10 days, madam. He was discharged on 4/10/2014. Injuries are, my lord, multiple puncture wound over left lower arm, lateral aspect, comminuted fracture of left humerus, fracture of left femur, my lord. That is the thigh bone, my lord. In this regard, my lord, pain and suffering is very meager, my lord. Tribunal has awarded 50,000, my lord. Yes, sustained
On multiple puncture wound over
left
left
arm, lateral aspect, comminuted fracture of left humerus. That is, and femur aspect. Total 3 injuries, my lord. And thereafter, my lord, he was operated for that injuries. Regarding disability, my lord, it was not extracted in the judgment properly, my lord, regarding the disability stated by the doctor. I had the copy of the certified copy of the doctor evidence, my lord. I have the certified copy of the doctor's evidence, my lord. It is particularly state that the regarding limb, my lord, upper limb is whole body disability is 13.33, my lord. Lower limb is 13.34, my lord.
So the tribunal took the disability in respect of whole body as
9% is it is wrong. Sorry, 8%.
Accident is
8%. It is taken 8%.
it took just 8%.
Yes, madam. Date of accident is 24/9/2014, madam.
2014. 8,500.
Madam. This is proper evidence.
Disability taken as 8% is proper, Mr. Counsel.
Submission.
No,
The
the discussion is on proper
It
lines.
is not extracted in the judgment, madam. On this reason, I am furnishing this separate copy of the doctor evidence.
Please,
Thanks.
take that.
Specifically stated that 24.645% total, 25%.
That is in respect of
whole
limb, my lord.
body.
1 minute, Mr. Counsel. After hearing the learned counsel for the appellant, will hear you.
Sir. Previous page mentioned in respect of upper limb. Totally 25%, man, and that was not considered, man. And also further, my lord, regarding income. He has stated that he was earning 12,000, but the tribunal has taken as 6,000, man.
So should be taken as 8,500.
Yes, madam. Regarding laid up period, madam. Regarding laid up period, madam.
Yes.
That's a very meager, my lord. And further, my lord, Food and nourishment only 20,000 awarded. And that is cost of damage is that is right, man. Regarding future medical expense, kindly see that judgment, man. Sorry, doctor evidence. It is stated that 75,000 previous page.
Accident occurred in the year 2014, Mr. Counsel. Let us hear, Mr. Vijay Kumar, what do you say?
My lord, regarding the disability, my lord, tribunal has rightly taken 8% disability based on the disability to the particular limb and whole body. My lord, if the disability to the limb is 24%, 25%, my lord, if 1/3 is taken, my lord, it is 8% to the whole body, that is rightly tribunal has taken. In case of upper limb, my lord, 1/4 to be taken. In case of lower limb, 1/3 to be taken. But your tribunal has taken, both are combined, and 1/3 is taken instead of 1/4. So therefore, my lord, the disability taken at 8% is just unreasonable. And my lord, regarding loss of immunity, some more amount may be awarded. And based on the notional income, my lord, 8,000, my lord, 8% disability that can be awarded. And medical expenses as usual, my lord. Loss of income during the period of treatment, my lord, only 2,000 is awarded. Kindly grant 3 months income loss of period treatment, my lord.
Yes.
And the loss of amenities, my lord, no compensation is awarded, my lord. Compensation towards loss of amenities may be kindly be awarded.
Yes.
And as far as damage to the vehicle is concerned, my lord, 3,10,000 is awarded. Absolutely, my lord, there is no basis, but we have not filed the appeal. If you had filed the appeal, my lord, entire 3,10,000 would have been reduced. Because absolutely no receipt, no document, how much the petitioner has spent for the damage to the vehicle.
It is not.
Insurance company has very, my lord,
It was discussed in para number 61.
consider it in not filing appeal. You should have proved how much he has spent for the damage to the vehicle and produced the receipt. And also should have produced whether he has claimed the insurance from his own company or not. That is a double compensation awarded by the tribunal.
Yes, Mr. Counsel.
Amenities to be minimum 50,000.
And interest is awarded at 7%, should be 6%.
We cannot change it. Yes.
Right. Disability, loss of future income has to be added, my lord.
So
Was
loss of earnings during laid-up period, we have taken the notional income as 8,500 per month.
please, my
Please, into 3 months.
It comes to rupees 25,500. And the notional monthly income is taken as 8,500 and calculated. So
My lord, 8,000 rupees, my lord, for the year 2000.
8,500.
500, yes, my lord.
8,000.
Yes, correct, my lord, correct. 8,500.
So loss of amenities, we have awarded 10,000. Total enhancement would be 57,780.
My lord, amenities to be minimum 30,000 has to be awarded.
Why 30,000? 2014 accident.
Please, man. Femur fracture and also is a driver, my lord.
How? Sri Prakash Hetsi, Land Counsel for the appellant, as well as Land Counsel for the appellant who appears physically before this court. Full stop. Also heard Sri D. Vijay Kumar, Land Counsel for respondent number 3 who appears through VC. Next. The claimant filed the appeal seeking enhancement of compensation and challenging the findings given by the Motor Accidents Claims Tribunal Kadur through orders in MVC 440 of 2015 dated 3rd March 2020. Full stop. Next, arguing the matter, Sri Prakash Hetsi submits that the appellant sustained grievous injuries due to the accident and became permanently disabled. Full stop. He, by working as driver, was earning rupees 12,000 per month by the date of accident. Full stop. However, the tribunal took the notional income as rupees 6,000 and awarded very meager compensation, and therefore the present appeal is filed. Full stop. Land Council also submits that the amount awarded as compensation under the head loss of earnings during laid-up period, that is rupees 2,000, is grossly low. Full stop. Land Council further submits that the tribunal has not awarded any amount towards loss of amenities in life, which is unjustifiable. Full stop. Land Council thereby seeks for enhancement of compensation. Full stop. Next paragraph. The submission that is made by Sri D. Vijay Kumar, Land Council for Respondent number 3, on the other hand, is that the tribunal awarded a sum of rupees 3,10,000 towards cost of damages to the vehicle, which is inappropriate. Full stop. Land Council, though contends that the amount of compensation under all heads is justifiable, yet fairly submitted that the loss of income during laid-up period granted is requires slight enhancement. Full stop. The tribunal, next paragraph, the tribunal through the impugned order awarded a sum of rupees 6,15,360 as compensation, divided under following heads, A to A. Next page. It is not in dispute that the appellant sustained punctured wound over left arm, comminuted fracture of left humerus and fracture of left femur, which are grievous in nature. Full stop. By all the evidence produced, the appellant succeeded in establishing that he took treatment at Kadur Government Hospital, thereafter at Nimhans, Bangalore, and later at St. Martha's Hospital, Bangalore. Full stop. Next, subjecting the evidence of CW1 to scrutiny, the tribunal took the disability in respect of whole body, which is functional in nature, as 8%, which needs no interference. Full stop. It is not in dispute that the appellant was aged about 28 years by the date of accident. Full stop. Though Land Council Sri Prakasha HC contends that the appellant, by working as driver, was earning rupees 12,000 per month, as rightly observed by the tribunal, no proof was produced to that effect. Full stop. However, having considered the submission made by both the Land Council that the figure adopted by the Karnataka State Legal Services Authority for the relevant period, that is for the year 2014, which is rupees 8,500, is required to be adopted. Full stop. Thus, taking the notional income as rupees 18,500 per month, the permanent functional disability as 8%, and applying the appropriate multiplier 17, the loss of future earnings due to permanent physical disability is as under. Notional monthly income 8,500, annual income 1,02,000, apply appropriate multiplier 17, 17,34,000, loss of future earnings, permanent physical disability being 8%,
Kindly be
1,38,720.
25% dated by the.
Next, the tribunal awarded a sum of rupees 1,14,440 only. The tribunal awarded a sum of rupees 97,920 only towards loss of future earnings. Full stop. Thus, the enhancement would be 40,800 within brackets 1,38,720 minus 97,920. Next paragraph. Having considered the nature of injuries sustained, this court is of the view that the appellant would not have attended his normal pursuits at least for a period of 3 months. Thus, the loss of earnings during laid up period comes to rupees 25,500. The tribunal awarded a sum of rupees 2,000 only towards loss of earnings during laid up period. Thus, the enhancement will be rupees 23,500. Within brackets 25,500 minus 2,000. Next, the tribunal failed to award any amount towards loss of amenities in life. Considering the grievous injuries sustained, this court is of the view that a sum of rupees 10,000 is required to be granted towards loss of amenities in life. Thus, the total amount which the appellant is entitled to receive, in addition to the amount that is awarded as compensation by the tribunal through the impugned order, is $74,300. Thus, in the light of the foregoing discussion, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Padur, through orders in MVC 440 of 2015, is enhanced by rupees 74,300. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition to the date of deposit. Next, the third respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, the appellant is permitted to withdraw the entire amount.
Much obliged, ma'am. Much obliged.
Serial number 30, Prakash HC, B Pradeep for R2.
Climate's appeal, madam.
Yes.
I am for
Case
respondent
of
for 2,
injury,
madam.
madam, in this case. Page number 7 of the judgment, madam. Para number 13.
Yes.
Got injuries, madam. Lacerated wound on the head, fracture shaft tibia left, fracture suprachiasmatic fracture of right femur, fracture shaft femur left, and fracture both the bone right leg, madam. He has taken the first aid treatment in Karnataka Government Hospital, madam. Thereafter shifted to Nagarajagowda Memorial Hospital, Mysore, and thereafter St. Joseph Hospital, Mysore, ESA Medical College and Model Hospital, Bangalore, madam. Totally was inpatient for 79 days, madam. $79 days. Further, madam. Regarding disability, madam, 53% to the right lower limb and 50% to the left lower limb, madam, and 10% to the right leg toe, madam. It will come around 103, madam, 113. Whole body disability is 38%, madam. The MSCT has taken as 30%, madam. in page number 9, para number 18, my lord.
What was his occupation?
He was working as a
Housekeeper at Century
housekeeper.
Club, Bangalore. Para number 12, my lord.
He stated that he was earning 12,000, my lord, but in the, as per salary certificate, 9,477 rupees, my lord.
His drawing salary, net taken home salary at 9,477 during the month of 2017 of November.
You have not examined the employer.
But yes,
For the year 2017, it should be 11,000.
But they
fine.
produced document salary certificate, my lord. Exhibit one, para number 12, my lord, judgment para number. Can I leave permitted to read, my lord?
Yes, as per the said certificate, it is 12,000 per month.
No, my lord.
yes, ma'am.
But accident, kindly below 3 lines, my lord. Exhibit P8 certificate reveals that he was working as a helper at Century Club, Bangalore. From 7/7/2014 to he was drawing net take home salary 9,477 during the month of 2017 November.
Records received. You have that exhibit
Exhibit P8, my lord.
P8.
They have produced exhibit P8 in that shows to 9,477 rupees per net salary.
We should have the document. We'll call for the records.
Please, my lord.
Heard Sri Prakash Hetsi, Land Counsel for the appellant, as well as Sri Mallikarjun Reddy, Land Counsel who represents Sri Pradeep B, Land Counsel on record for respondent number 2. Admit, call for the records from the consent tribunal. This is the matter under the caption final hearing on 30th September.
Please, my lord. Much obliged.
Much obliged.
Serial number 31, Manjunath ND.
I am for respondent. On behalf of Lakshminarayan, I am representing, my lord.
Serial number 31.
No representation on appellant side on call. Sri Pradeep B, Sri Mallikarjun Reddy representing Sri Lakshmi Narayan C, Land Counsel on record for respondent number 2 is present before this court physically. To give fair opportunity. List on 23rd September.
Please, my lord.
As Sri Lakshmi Narayan C is on record for respondent number 2, office is directed not to show the name of Sri Ashok N. Patil hereafter in the cast list.
Serial number 32, Vishwanath Pujari, B Pradeep for R2.
I am for appellant, my lord. Insurance company challenging liability, my lord. Meanwhile, required TCR, my lord, in this matter. We have deposited before tribunal, my lord.
Heard. Sri Vishwanath Pujari K, Land Counsel for the claimant, as well as Sri Mallikarjun Reddy, who represents Sri Pradeep B, Land Counsel on record for the insurance company. Admit both the appeals. Call for the records from the consent tribunal.
Please, my lord.
List both the matters under the caption final hearing on 21st October.
Serial number 33, 34, Adjournment. 35, Shripad Shastri.
My lord, I am for appellant, my lord.
DC Sitaram Rao.
My lord, it's a case of injury. My lord, due to subsisting disability, my lord, he now unable to.
Other side, Mr. Counsel.
No, I appear for the respondent, Madam. I'm ready.
Yes, Mr. Counsel, yes.
My lord, the date of accident is 23/6/2018. My lord, it is only on quantum.
Yes.
My lord, page number 9, para number 14 is relevant. My lord, He is 31 years old at the time of accident and he is working in a small hotel as a cashier. The doctor's evidence is to be looked into while assessing the compensation towards future loss of earning and earning capacity. He claims to be earning 15,000 per month. But no legally acceptable proof is produced to prove his income. The injury sustained is fracture of left leg, both the bones of left leg, second, third, 4 and 5 metatarsal bone, severe head injury resulted in subjugal hematoma.
Yes.
Multiple nerve injury. This is a neuropathy. Polyneuropathy. Took a long period of hospitalization. First at Shanbag Hospital, next Madhu Hospital, Nimans Hospital. Hosmat Hospital, first time 37 days he was inpatient. That is 23/6/37/2018. Thereafter, Savita Hospital for 34 days. Again in Hosmat Hospital 4 days. Again Hosmat Hospital for 3 days. And last Sanjay Gandhi Hospital for 11 days. So, 5 occasions he was treated as inpatient and underwent several surgeries. I have examined 2 doctors, PW 2 and 3. I want to draw my lord's attention regarding the doctor's evidence.
Yes.
His contention is, after accident, because of this neurological deficiency, neurological disability, he is now not in a position to continue his avocation in a small hotel as a cashier. He has been removed. That is his contention. To substantiate the same, PW2 and PW3 doctor evidence is very much important. First, PW3, I want to draw my lord's attention regarding PW3's evidence. PW3 is a neurosurgeon.
Yes, Mr. Counsel. PW3.
In the doctor's evidence, PW3, second page of the affidavit, the procedure which he underwent, it's all substantiated. Thereafter, disability assessment, para 7 of the affidavit. It reveals that due to this impairment of attention and motor speed, nerve and learning memory, it is all affected. He become the neurological disabled for 15% whole body disability, but his functional disability is, my respectful submission is required to be considered apart from this orthopedic disability and neurological disability. It is to be considered at a higher scale. May I read the disability assessment, Problem statement.
Where is the disability assessment?
That is a PW3. First, I want to draw my lord's attention regarding PW3's evidence. Second page, disability under the caption of disability assessment. Disability assessment.
Yes.
He was assessed on 27/6/2019 for disability assessment. Problem statement. Patient claims that he has difficulty in remembering things associated with emotional disturbance and difficulty in learning new tasks. Patient for this issue was investigated with an MRI of the brain and detailed psychometric assessment by a qualified neuropsychologist. The MRI report showed hyper-intense area in the frontal region on both sides, which are consequence of said head injury. The neuropsychiatric assessment showed severe impairment of attention, motor speed, and learning and memory. He had moderate to severe mental depression. The calculated impairment to whole body as a consequence of these deficits is complex integrated cerebral function is 15% in addition to other orthopedic disability. Right, in view of the MRI showing a signal changes, these problems are likely to be permanent in nature. On my advice, the patient has referred for obtaining neuropsychological report. The same is already produced as Exhibit P13. I accept the finding therein and overall cognitive functions, neuropsychological assessment as mentioned therein. So, my lord, this doctor is a neuropsychologist. According to him, my lord, there is a severe mental impairment. Now I come to PW2's evidence, my lord.
So the his assessment is that there is
15%.
overall cognitive functions, neuropsychological assessment, the disability is 15%.
15% as well as neurological deficiency is concerned. It's the second part. First part is orthopedic disability. My lord, PW2's evidence is important. I have examined to my fracture, disability and injury sustained to my bones, my lord, fractures. PW2's evidence, my lord. My lord, PW2's evidence, para 2.
Yes.
Para 2, injury is narrated. Fracture of left leg, both bones of lower part, left foot, second, third, and fourth metatarsal, and head injury. Well, at admission and hospital, there is all the disability assessment. The procedure underwent, but 3 times he was inpatient in a hospital. 3 times. Well, even though he after lapse of years together, well, in the year 2020, I examined the doctor. 2018, well, accident occurred. Even after lapse of 2 years, well, just even the bones are not fully united, according to PW2's evidence. Well, the disability assessment in para 8 and 9 of orthopedic, well, the patient says that he was a cashier in a hotel before the accident. He says that he is unable to work. He says that he has a great difficulty in kneeling, squatting, sitting cross-legged, and climbing stairs and slopes. He says that he has swelling, stiffness, and pain with scarring and disfiguration in his left knee, left ankle, and left foot. He says that he develops fatigue and pain and swelling of his left leg and ankle and left foot on attempted walking. He says that he has pain on turning on the left. He says that he has disfiguration and scarring in his left leg, scarring in his left leg. He says that his left leg is crooked and deformed, and he walks on the inner border of his left leg, left foot. He says that he walks with a limp and needs a support. But even after lapse of 2 years, he required support. Well, left lower limb disability is assessed, stability component and other adding future surgery. Next future surgery, para 13. Using combined value in para 12, whole body disability assessed 20%. But future surgery, he requires surgeries, implant removal, and
yes.
And another 2 corrective osteotomy to correct the deformity, which will cost 90,000. The orthopedic disability is 20%. Apart from 15% whole body of as far as neurological aspect is concerned. But since he is working in a small hotel as a cashier and he is unable to continue his avocation, which is established through doctor's evidence. My lord, the disability tribunal considered as 15% is too low. My lord, it is required to be considered higher than the physical and neurological disability. That is the first point, my lord. Income considered at 10,000, my lord, as per chart, it is 12,500. May I read mention the compensation awarded, my lord?
Yes.
My lord, pain and suffering 60,000. My lord, he underwent several surgeries, which is forthcoming in the doctor's evidence and discharge summaries.
Yes.
It requires enhancement. And amenities, my lord, he is 31 years old, my lord. The subsisting disability is totally taken away is a normal life. So amenities 40,000 seems to be lower side.
Yes.
Well, 10,70,404 medical bills, 10,70,404. That has been accepted by. Incidental expenses 50,000. Loss of earning 1,40,000 is considered awarded by considering 10,000 as salary income and 14 months. Well, from the date of accident up to the date of trial, my lord, you are totally walking with the help of crutches, and this absolute loss period is required to be considered at least 2 years.
Yes.
And as far as future loss is concerned, my lord, even though total body disability comes to 35%, my lord, 20% orthopedic, 15% neurological. My lord, 15% is considered, my lord, according to my respectful submission. My lord, physical disability, my lord, functional disability is required to be considered as more than 35% because he is totally unable to continue his avocation in the young age of 31 years.
Yes.
At least 50%, at least, my lord, and future prospect is to be added. The loss of marital life, if it seems to be deemed fit, my lord, to some extent, my lord, it is required to be compensated. That's all, madam.
May I submit, my lords?
Yes, Mr. Counsel.
My lords, PW2 doctor in his cross-examination states, my lords, that the petitioner can do desk job. There is no evidence on record to show that the petitioner cannot continue with his job, or no doctor has said that he cannot work. There is no functional disability so far as the physical disability is considered. Hence, my lords, the trial court has rightly taken 15% functional disability because there is neurological disability. My lords, with regard to income, my lords, it has to be taken at 12,500. I have no say with regard to that, my lords.
Yes.
Rest I leave it to the court, my lords. Conventional heads, I leave it to the court.
May I make one submission?
Yes.
Well, keeping in mind the evidence of the doctor and severe head injury sustained, my lord, it is established, my lord, neurologically, my lord, is impairment of the attention, motor speed means, my lord, every limb speed, my lord, and the learning of memory is badly affected. Since he is coming under the manual labor capacity, this one, my lord, I made the submission that functional disability is required to be considered on higher side. That is my respectful submission. That's all.
But it is not the doctor's evidence, my lords, it is just submissions.
My lord, it is all supported. Every submission is supported by the evidence of the doctor. PW3's evidence may kindly be scrutinized. It reveals.
PW3 stated that he should be again reevaluated after 1 year.
But as the same, my lord.
And that apart, he the observation made by the court is he appeared before the court and gave rational answers and.
That is correct, my lord. They see the brain, the effect on brain, that is yeah, on several aspects, my lord. Suppose somebody else met with a head injury, my lord, some may not able to recollect these numbers. Some may not lost the memory of earlier days. Some may not able to calculate. It's all affected areas in brain. That is why, my lord, the overall these effect of these PW2 and 3, that is orthopedic surgeon and the neurosurgeon, it gives an impression. It gives an impression that this person, this victim, now his earning capacity is substantially reduced. That is my purpose.
We have taken the notional income as 12,500. We have not disturbed the disability. The total enhancement would be 2,56,000.
Well, remaining heads, madam.
Remain pain and suffering, tribunal awarded 60,000. We have awarded 1 lakh.
Amenities, madam.
No other changes.
Amenities and marriage, marital life, loss of, because, my lord, these are, anyway, it is left to the court.
Yes. Third. Sri Shripad V. Shastri, learned counsel for the appellant, who appears through video conference. Also heard Sri Anup Sitaram Rao, learned counsel for respondent number 1, who also appears through VC. Next, challenge in this appeal is the order that is rendered by the Principal Motor Accidents Claims Tribunal, Bangalore, in MVC 5364 of 2018, dated 24/2021. As against the claim for rupees 15 lakhs in total, the tribunal awarded a sum of rupees 17 lakhs 18,500 as compensation, and being not satisfied with the said sum that is awarded as compensation, the claimant is before this court. Next, arguing the matter, Sri Shripad V. Shastri submits that the appellant sustained grievous injuries due to the accident and became disabled both physically and neurologically. Though, through the evidence of PW3, the neurological disability was established, and through the evidence of PW2, the functional disability was established, the tribunal did not award justifiable sum as compensation, and therefore this appeal is filed. Bringing to the notice of this court the evidence of PWs 2 and 3, and counsel seeks for enhancement of compensation. Land counsel also submits that, next paragraph, Land counsel also submits that the appellant, by working in a private firm, was earning rupees 15,000 per month. However, the tribunal took the notional income of the appellant as rupees 10,000 per month, which is unjustifiable. Land counsel also contends that the accident occurred in the year 2018, and for the relevant period, even the Karnataka State Legal Services Authority is taking the notional income as rupees 12,000 per month, and at least the said figure should have been considered by the tribunal. Sri Anup Sitaram Rao, Land counsel for respondent number 1, did not deny the submission that is made by Shripad V. Shastri regarding the notional income to be taken at the rate of rupees 12,500 per month. However, Land counsel contends that the amount awarded as compensation under all other heads is justifiable. Next paragraph. The tribunal, through the impugned order, awarded a sum of rupees 18,500 as compensation divided under following heads, A to E. It is not in dispute that the appellant sustained fracture of both bones of left leg
ಶಾಸ್ತ್ರಿಗಳೇ ಪೋರ್ಟಲ್ ನಂಬರ್ 10 ಮ್ಯೂಟ್ ಮಾಡಿ.
that is tibia and fibula, comma, grievous injury to second, third, fourth and fifth metatarsal bones of left foot and also a head injury. Construct. Equally, it is not in dispute that interlocking nailing of left tibia was done, comma, plating of left lateral malleolus was done, and multiple K wiring to left foot was also done. Full stop. The evidence of PW3 is that the appellant was admitted at Hosmat Hospital on 23/6/2018 and he was managed conservatively for the head injury, comma, he was on ventilator for some time, comma, tracheostomy was done to help breathing, comma, there was intensive monitoring, and he was discharged on 30/7/2018. Full stop. He also deposed that the appellant again got admitted at the same hospital on 18/3/2019 and bone grafting, comma, fibulectomy and dynamization was done, and he was discharged on 21/3/2019. Full stop. He was again admitted at the same hospital on 18/5/2019 and conservative treatment for infection was done and was discharged on 25/2019. Full stop. He also deposed that the appellant took further treatment at Sanjay Gandhi Hospital where ring fixation was done. Full stop. The evidence thus produced reveals that the appellant sustained grievous injuries due to the accident and took extensive treatment. Full stop. Next, taking into consideration the evidence of PW2 with regard to the functional disability and the evidence of PW3 with regard to the neurological disability, and further making an observation that the appellant appeared before the court, gave evidence as PW1 and stood for the test of cross-examination, comma, the tribunal assessed and took the disability in respect of whole body as 15%. Full stop. The said observation needs no interference. Full stop. Next, taking into consideration, admittedly, the appellant has not produced any substantive proof with regard to his actual occupation and earnings by the date of accident. Full stop. However, both the learned counsel sought for taking the notional income as rupees 12,500, which is justifiable. Full stop. Thus, taking the notional income as rupees 12,500 per month, comma, the appellant being aged about 31 years by the date of accident, comma, adding 40% towards future prospects and applying the appropriate multiplier 16, comma, loss of future earnings due to permanent physical disability is as under. Notional monthly income 12,500, annual income 1,50,000, add 40% towards future prospects 2,10,000, apply appropriate multiplier 16, 33,60,000, loss of future earnings, comma, permanent physical disability being 15%, 5,04,000. Next, the tribunal through the impugned order awarded a sum of rupees 2,88,000 only towards loss of future earnings. Full stop. Thus, the enhancement would be, enhancement on that count would be 2,16,000 within brackets 5,04,000 minus 2,88,000. Next, having considered the nature of injuries sustained and the treatment taken, comma, this court is of the view that the appellant is entitled to a sum of rupees 1 lakh towards pain and suffering, towards compensation, as compensation towards pain and suffering. Instead, the tribunal awarded a sum of rupees 60,000 only under the head pain and suffering. Thus, the enhancement would be 40,000 within brackets 1 lakh minus 60,000. Full stop. Taking the notional income as rupees 10,000 per month, comma, observing the fact that the appellant would not have attended his normal work at least for a period of 1 year, 2 months, that is 14 months, comma, the tribunal awarded a sum of rupees 1,40,000 as compensation towards loss of earnings during laid up period. Full stop. However, taking the notional income as rupees 12,500 per month, comma, the loss of earnings during laid up period comes to rupees 1,75,000. Full stop. As earlier stated, the tribunal awarded a sum of rupees 1,40,000 only under the head loss of earnings during laid up period. Full stop. Thus, the enhancement would be 35,000. Thus, the total compensation which the appellant is entitled to receive in addition to the compensation that is awarded by the tribunal is 2,91,000 within brackets 2,16,000 plus 40,000 plus 35,000. Full stop. In the light of the foregoing discussion, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal Principal Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 5364 of 2018 dated 24/2021 is enhanced by 2,91,000. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition to the date of deposit. The second respondent is, the first respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. On such deposit, the appellant is permitted to withdraw the entire.
Next. Seal number 36, Mallikarjuna NS, BC Shivannegowda for R3.
This is the case of injury, my lord. The appellant has sustained 2 injuries, CLW, that is page 10 of the judgment. CLW 4 × 1 centimeter of chin, 2 comminuted fracture of left proximal tibia and fibula. These are the injuries he has sustained. The doctor has assessed he was inpatient for more than 13 days. The doctor has assessed 43% to the left lower limb disability, and the court has come to the conclusion that he has suffered 30% disability, whereas while awarding the compensation, the tribunal has taken the disability as 12% instead of 30%. The monthly income taken as 12,500 since the date of accident is of 2018. That is correct, my lord. And then loss of totally awarded 4,56,000 on our various heads. Loss of future running 2,17,000. Taking disability as 12% disability instead of 30%. Towards pain and agony 40,000. Medical bills actually is 1,08,430. The same is awarded. And then cross loss of income for the laid up period is 50,000 for 4 months. And loss of amenities 20,000 and conveyance, diet, etc. is 20,000. So at page 15 of the judgment, the
We
trial,
don't find any information in the order, Mr. Counsel.
in page 15, you may kindly see, PW2 in respect of the left lower limb of the petitioner cannot be considered as 43%, but it is to be restricted to 30% as admitted by the PW2.
That is in respect of a limb.
Limb.
That cannot be taken as whole body.
That in this case, in fact, insurance company should have been filed the appeal, my lord. For this injury also future prospect is taken, but our company has not preferred the appeal.
So any
All
increase
other rate, my lord,
globally? Any increase globally?
my lord, according to me, another 10,000 rupees to be granted under the amenities as per that. But considering that, my lord, they are not entitled to get any compensation.
Yes. Yes, Mr. Counsel,
Yes, suffering
how much increase you expect globally?
another 50,000.
It's too high.
Will increase by 30,000. Yes.
Please.
Third. You are Mr. Mallikarjuna.
NS
Third, Sri Mallikarjuna NS, done counsel for the appellant, as well as Sri PC Shivannegowda, done counsel, who represents respondent number 3 insurance company. Next. dissatisfied with the amount that is awarded as compensation, the claimant is before this court, challenging the order that is rendered by the Additional Motor Accidents Claims Tribunal Kundapura in MVC 76 of 2019, dated 31/5/2021. Full stop. By Sri Mallikarjuna NS, arguing the matter contends that the amount awarded as compensation is grossly low, Sri B.C. Shivanagowda, Learned Counsel for Respondent number 3, contends that submits that the amount awarded as compensation under all heads is excessive, and indeed, Respondent number 3 insurance company should have preferred an appeal. Full stop. It is not in dispute that the appellant sustained a lacerated wound over chin, which is simple in nature, and a comminuted fracture of left proximal tibia and fibula, which is grievous in nature. Full stop. Subjecting the evidence of PWs 1 and 2, exhibits P4 to P99 to scrutiny, the tribunal awarded a sum of rupees 4,56,230 as compensation, divided under following heads, A to E. Full stop. Next, during the course of arguments, Sri Mallikarjuna NS as well as Sri B.C. Shivanagowda mooted a proposal of awarding certain sum as global compensation in addition to the amount that is awarded by the tribunal. Full stop. Having considered the nature of injuries sustained, the treatment taken, and the amount that is awarded as compensation by the tribunal, this court is of the view that a sum of rupees 30,000 globally is required to be enhanced so that the compensation that the appellant would get would be justifiable and wholesome. Full stop. Therefore, the appeal is disposed of with the following order. The compensation that is awarded by the Motor Accidents Claims Tribunal through orders in Additional Motor Accidents Claims Tribunal Kundapura through orders in MVC 17, dated 31/5/2021, is enhanced by rupees 30,000. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. The third respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. On such deposit, the appellant is permitted to withdraw the entire.
Number 37, adjourned. 38, MV Maheshwarappa.
This case, appellant filed for 4 cases for enhancement of the compensation or injuries. Date of accident, your lordship, on 14/11/2017. In first case, left hand is amputation. Working as a tailoring. The income taken by the tribunal is 9,000. The 2017 is 18,000, that is 11,000. In addition, the future loss of disability not added, your lordship. The photo produced, your lordship, the amputation of left hand. Doctor says 30% of the whole body. First case, your lordship. Page number 41, your lordship. That is 40, no. Page number 31. Internal trial court judgment is 22, para number. 31, ink page number. Petitioner had sustained left open type 3rd C fracture both bones forearm with near total amputation at the level of wrist and left mid shaft humerus fracture for which she has underwent external fixator application for humerus forearm with debridement and explanation, revascularization and repair. Further, she underwent left mid forearm amputation, external fixator removal, ORIF with plating of humerus. This fact has been corroborated by the contents of Exhibit P4 wound certificate and Exhibit P6 discharge summary issued by the MS Ramaya Hospital, wherein she took treatment as inpatient from 14/12/2017 to 23/12/2000. PW1 has also produced Exhibit P7, which are medical bills 8,04,364. Exhibit P8 photographs. Now, David photo torso. Left, that is exhibit. Left hand amputation agide. She is the lady. Otherwise. ತಗೊಳ್ಳಿ.
ಅದರಲ್ಲಿ ಅನೂಪ್ ಸೀತಾರಾಮ್ 4 ಕೇಸ್ ಇದೆ. 4 ಕೇಸ್ ಇದೆ. ಅವ್ರು ಹಾಕಿಲ್ಲ. ಅವ್ರು ಹಾಕಿಲ್ಲ. ಮಿಕ್ಕಿದ 3 ಕೇಸಲ್ಲಿ ನಾನು ಹಾಕಿದ್ದೆ ಕನೆಕ್ಟ್.
Next, your lordship, para number 25. In the cross examination, he has admitted that he has treated petitioner personally and now the humerus fracture of united. Further, they denied the other suggestion made by the first respondent counsel. If the oral evidence PW6 is perused, this accident was occurred in the year 2017. PW6 has assessed the disability in the year 2020. That means 3 years after the date of accident. His own admission in the chief examination reveals that the petitioner has underwent total amputation at level of wrist, and now the humerus fracture was united. Hence, the court deems to be fit. The say compensation degree of disability for the whole body will be taken as 30%. Now, kindly, your lordship, see the amputation. Lady.
Yes, Mr.
I have produced before the trial court and marked. The income taken by the only for 9,000, the 2017 is 11,000. In addition, your lordship, 25% will be added because age is 41 years. As per the Pranaya set, the laws of disability. In other heads, your lordship, these on lawyer side, the tribunal award pecuniary damages and non-pecuniary damages. Treatment, hospitalization, medicines, 6,96,000. And loss of earning which injured have made not been injured, that is kottilla, otherly not awarded. Loss of earning during the period of 9,000, only 1 month kottida. He has admitted following the treatment more than 6 months, your lordship. Loss of future earning, 9,000 income taken, page number 39, your lordship. Page number 39, 9,000. Addition 30%, that is, your lordship, the kindly may, as per the ECA, 60% your lordship take into consideration. But here is MUSIC, no doubt that is filed.
Yes.
30% the whole body, the disability, doctor says PW6, your lordship. Totally, your lordship, the award by the tribunal is on lawyer side and inadequate. This is the first case, your lordship. Amenities is on lawyer side. Disfiguration and special diet is on lawyer side. Page number 40. She is aged about 41 years, working as a tailoring work.
Not tailor, Mr. Counsel. In
Swami?
the second case, you are-
Tailoring.
In which case you are arguing?
The
one?
first case, first case.
He is not a tailor.
He is working as a vegetable vendor. That is, sorry. Business.
Provision store and flower.
Flower vendors and vegetables. Satisfied.
Yes, Mr. Council.
As per income, my lord, they have not produced income, my lord. Maybe notional income may be taken, my lord. Another disability, my lordship, trial court has been taken consider correctly, my lord. Maybe disability may be same, may be taken on. Other rates, my lordship, loss of income during treatment period, maybe 3 to 4 months, maybe that may be granted, my lordship. In future medical expense, 50,000 rupees has been awarded, and that may be same, may be returned, but because 2017 accident, till today, they have not produced any document of future medical expenses, my lord. Pain and suffering, already 2 lakh rupees has been granted, my lordship. That may be same, may be retained, my lordship. Loss of amenities, 50,000 rupees awarded.
That is on lower side.
Compensation, special diet and attendance charges, 30,000 rupees has been awarded. Maybe reasonable is my lordship, maybe.
30% loss of future disability not added to your lordship, as per the finance.
Yes.
This is the first case, your lordship.
Rate of interest, 9% is there. My enhancement amount may be 6%, my lord.
So we have taken notional income as 11,000.
11,000.
Added 25% towards future prospects.
Yes.
The appropriate multiplier is 15.
15,
And the disability is 30%.
30%.
So it comes to rupees 7,42,000.
So 300.
So the tribunal awarded 6,32,000.
Oh, yes.
Enhancement would be 1,10,500.
Please, my lord.
So loss of earnings during laid up period, we have taken for 8 months. So 88,000, tribunal awarded 9,000 only, there the enhancement would be 79,000.
70.
And the loss of amenities, tribunal awarded 50,000 only, we have taken it as 1 lakh. Enhancement would be 50,000. So the total enhancement would be 2,39,000.
Food and nutrition is admitted in the hospital, your lordship, that is lower side.
30,000 is awarded.
Is already
Mr. Counsel.
30,000 rupees has been awarded.
Food and nutrition, that is 20,000. Nourishing food and miscellaneous expense.
Again, food and nutrition, 20,000 is added, given, and compensations for special diet, 30,000 is.
Please, my lord.
No further.
Yes.
Column number 5.
Heard. So we'll dispose of all the appeals.
Oh,
Please, ma'am.
Matters are there.
I will argue.
We'll dispose. A common judgment, but I'll dictate in
Uh,
parts. Heard.
Next. May
3. M.V. Maheshwarappa, Land Council, who appears for the appellants in all the 4 appeals. Also heard Sri Mallikarjun Reddy, who represents Sri Pradeep B, Land Council on record for respondent number 1, insurance company, in all the 4 appeals.
In 1 lakh, 8
Heard Sri B. Pradeepama, B. Pradeep, Land Council, who appears for respondent number 1 in MFA 988 of 2022, MFA 603 of 2022, and MFA 656 of 2022. Full stop. B. Pradeep name is also mentioned. Mr. Anup Sitaramarao,
Milods,
are you appearing for the respondent in MFA 3909 of 2021, 38.1 matter?
please, Milods. Yes, Milods.
Yes. Also heard Sri Anup Sitaramarao, Land Council, who appears through VC and represents respondent number 1 in MFA 2909 of 2021. Next. D. Claimant in MVC 2642 of 2018 you remove that. All these appeals arise out of the common order that is rendered by the Motor Accidents Claims Tribunal, Bangalore, in MVC 2649 of 2018, 2650 of 2018, 2651 of 2018, and 2642 of 2018. Dated 29/1/2021. Good stuff. All these appeals are for are filed seeking enhancement of compensation. Good stuff. Next one. Entitlement of compensation by the appellant in, that is heading 1. entitlement of compensation by the appellant in MFA 988 of 2022, who is claimant in MBC 2642 of 2018. Good stuff. The undisputed facts in this case are as under. One, the appellant sustained grievous injuries that occurred in a road traffic accident on 14/12/2017. Next, the appellant was aged about 40 years by the date of accident. Full stop. Next, though the appellant contended that by running a provision store and by selling flowers, she was earning rupees 20,000 per month, no proof was produced to that effect. Next, that the appellant sustained open type 3C fracture, both bones of forearm and left mid shaft humerus fracture. Next, that the appellant underwent external fixator application for humerus with debridement. Next, that the appellant underwent left mid forearm amputation Full stop. That PW6 Dr. Mahesh assessed the disability in respect of left upper limb as 90% and the whole body as 30%. Next. Next paramma. Arguing the matter, Learned Counsel Sri M.V. Maheshwarappa contends that the appellant lost her left forearm and is suffering a lot. Full stop. Though by running a provision stores and by selling flowers, the appellant was earning rupees 20,000 per month, the tribunal took the notional income as rupees 9,000 per month, which is unjustifiable. Full stop. Learned Counsel also contends that the appellant was hospitalized for more than 10 days, where she underwent surgeries, but the tribunal awarded a meager sum under the head loss of earnings during later periods, which is unjustifiable. Full stop. Learned Counsel thereby seeks for enhancement of compensation. Full stop. Though Learned Counsel Sri Mallikarjun Reddy submits that the amount awarded as compensation is justifiable, Learned Counsel did not deny the submission, but Learned Counsel endorsed to the submission made by Learned Counsel for the appellant that as the accident occurred in the year 2017, as considered by the Karnataka State Legal Services Authority, the notional income is required to be taken as rupees 11,000 per month. Full stop. Next, the tribunal through the impugned order awarded a sum of rupees 17,37,000 as compensation divided under following heads. A to E. Full stop. Having taken the notional income as rupees 11,000 per month, the appellant being aged about 40 years by the date of accident, adding 25% towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case, applying the appropriate multiplier 15 as per the decision of the Honorable Supreme Court of India in Sarla Verma's case, and the permanent physical disability in respect of whole body being 30%, the loss of future earnings due to permanent physical disability is as under. Notional monthly income 11,000, annual income 1,32,000, add 25% towards future prospects 1,65,000, apply appropriate multiplier 15, 24,75,000, 30% loss of future earnings, 30% being permanent physical disability 7,42,500. Next way. The tribunal through the impugned order awarded a sum of rupees 6,32,000 only towards loss of future earnings. Full stop. Thus, the enhancement in this regard will be 1,10,500. Within brackets 7,42,500 minus 6,32,000. Full stop. Next para. Admittedly, the appellant underwent left mid forearm amputation. Full stop. Having considered the trauma faced through such amputation and the pain and suffering, this court is of the view that the appellant would not have been in a position to attend her normal pursuits at least for a period of 8 months. Full stop. Thus, the loss of earnings during laid-up period comes to rupees 88,000. Within brackets 11,000 into 8. Full stop. However, the tribunal awarded a sum of rupees 9,000 only towards loss of earnings during the period of treatment. Full stop. Thus, the enhancement would be 79,000. Within brackets 88,000 minus 9. Full stop. Also, this court is of the view that the appellant is entitled to a sum of rupees 1 lakh towards loss of amenities in life. Full stop. The tribunal awarded a sum of rupees 50,000 only. Full stop. Thus, the amount, the enhancement would be 50,000. Within brackets 1 lakh minus 5,000. Full stop. Thus, the total compensation which the appellant is entitled to, in addition to the sum that is awarded by the tribunal, is 2,39,500. Within brackets 1,10,500 plus 79,000 plus 50,000. Full stop. Thus, with the foregoing discussion, this court ultimately holds that the appellant is entitled to an additional sum of rupees 2,39,500.
In next.
Yes.
Next case is page number 57.
Next, entitlement of compensation. Where is the next one?
Page number 57, the judgment. DM Sujata, the MFA 2909/2021, MUC 2651.
Entitlement of compensation by the appellant in MFA 2909 of 2021, who is the claimant in MBC 2651 of 2018. Where is the discussion?
That is in trial court judgment 49.
Page number 49, my lord.
49, trial court judgment.
Court officer?
MUC 2651. Trial court judgment 49. Page number. Aged about 30 years.
31.
That is 26 plus 17 multiply. The income, page number, para number 56.
1 minute, Mr. Counsel. Sustained splenic injury and fracture of left sacral ala.
Lateral.
Splenectomy was done and one sacral.
Splenic injury and fracture of left scapula, for which he was operated and emergency splenectomy was done.
Yes.
And managed conservatively for fracture of sacrum. This has been corroborated by the contents of Exhibit P20 and 21. As per the Exhibit 21 wound certificate and discharge summary issued by the MS Ramaya Memorial Hospital, wherein she took treatment as inpatient on 14/12/2017 to 25/12/2017. PW4 has also produced Exhibit 22 medical bills to ton of rupees 2,20,871. Exhibit P3 23 medical prescription and Exhibit 24 25 photographs with CD and Exhibit P6 X-ray. In the written argument, the first respondent counsel contended that the petitioner has produced one photo physiotherapy bill issued by the Focus Diagnostic Center for the amount of rupees 15,000 in serial number 52. The bill issued on 10/10/2018 for physiotherapy charges from 10/2/2018 to 9/10/2018 and bill 297. The bill issued on different dates, but the bill number are given serial wise by the Focus Diagnostic Center. Some bills are issued before the commencing treatment and some bills are issued after giving treatment. The bill issued by Focus Diagnostic Center is not an authenticated bill. The bill on serial number 55, 56, rupees 23,790, 7,390 issued on 3/7/19 to 5/7. Inner Health revealed serial number 62 issued by 7/10/2019 and 14/4/2000 by Manipal Hospital for general blood test and other checkups which are not related to the accidental injuries. In respect of medical bills are considered, both the petitioners, the first respondent counsel have filed memo stating that petitioner has filed list of medicals, page number 1 to 3, serial number 5 to 16, 17 to 40, 41 to totally 32,767, your lordship, which has to be deducted. It comes 1,88,103, the awarded totally the 1,88,000 medical bills award. The petitioner examined Dr. K.R. Kantraj, orthopedic surgeon at General Hospital Devanhalli. PW9 got marked Exhibit P37 and 38, OPD card X-ray. PW9 has assessed disability due to pain, the lower back radiating to left lower limb, 25%. That is PW doctor, that is Kantraj. Examined by the tribunal, your lordship.
Yes, Mr. Counsel. On what counts you are seeking for enhancement?
Income, that is income 9,000 taken. In other head is on lawyer side, yes.
Yes, In this case, Mr. Sitaramana, what do you
My
say?
lords, it can be considered, my lords.
And 15% whole body ಹೇಳಿದ್ರು.
Yes. Listen. Entitlement of compensation by the appellant in MFA 2909 of 2021, who is the claimant in MVC 2651 of 2018.
DM Sujata.
Yes.
The undisputed facts of the case are as under. One, the appellant sustained injuries in a road traffic accident that occurred on 14/12/2017. The appellant was aged about 30 years by the date of accident. Though the appellant contended that by doing vegetable business, she was earning 18,000 per month, no proof was produced before the tribunal to that effect. Next, that the appellant sustained splenic injury and fracture of left sacral ala, which are grievous in nature. That splenectomy was done and the fracture of sacrum was managed conservatively. That the appellant took treatment as inpatient for a period of 11 days. Next. Three, M.V. Maheshwarappa, land counsel for the appellant, submits that the only grievance of the appellant is that the notional income was taken as rupees 9,000 per month, and in fact for the relevant period, even the Karnataka State Legal Services Authority is taking the notional income as rupees 11,000, and at least the set figure should have been considered by the tribunal. Sri Anup Sitaramana, land counsel who appears through VC and represents respondent number 1, did not deny the request made by land counsel for the appellant to take the notional income as rupees 11,000 per month. Also, the request made is justifiable. Next page.
And amenities is on lawyer side, only 20.
Thus, amenities 20,000 is given. Thus, taking the notional income as rupees 11,000 per month, comma, the appellant being aged about 30 years by the date of accident, comma, adding 40% towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case, comma, applying the appropriate multiplier 17 as per the decision of the Honorable Supreme Court of India in Sarla Verma's case, and the permanent physical disability being 15%, comma, the loss of future earnings due to permanent physical disability is as under. Notional monthly income 11,000, annual income 1,32,000, add 40% towards future prospects 1,84,800, apply appropriate multiplier 17, 31,41,600, loss of future earnings, comma, permanent physical disability being 15%, 4,71,240. Next, the tribunal through the impugned order awarded a sum of rupees 2,76,000 only towards loss of future earnings. Full stop. Thus, the enhancement will be
Lordship, the laid up period.
rupees 1,95,240 within brackets 4,71,240 minus 2,76,000. Next paragraph. Having considered the nature of injuries sustained, comma, This court is of the view that the appellant would not have attended her normal pursuits at least for a period of 4 months. Full stop. Thus, the loss of earnings during laid-up period comes to rupees 44,000 within brackets 11,000 into 4. Full stop. However, the tribunal awarded a sum of rupees 9,000 only under the said head. Full stop. Thus, the enhancement will be 35,000. Full stop. Thus, the total amount which the appellant is entitled to, in addition to the amount that is awarded by the tribunal, is ₹2,30,240. We'll decide rest of the matters afterwards.
Please, my lord.
My lord, one request. No. My lord, one submission. Serial number 55.
55.
5. And for the appellant in this matter, which time may be granted. In the meanwhile, madam, I will serve the copy to the respondent number 2, insurance company.
Sri B. and
Second
Sri is on
respondent.
record. You are Mr. Ramesh Kyan.
My name is Sunil P. My senior name is Ramesh Kyan.
Sri Sunil,
Please.
representing Sri Ramesh Kyan, Land Council on record for the appellant seats time. Hence, stand over to 30th September.
My lord, sir, in serial number 49.
What?
49.
Yes,
Please,
my
my
lord.
lord.
Yes, Mr. Council.
My lords, I appear for the appellant in my lords, MFA number 5244 of 23. My lords, I need to take my lords fresh steps to my lords respond number 3 for second time, my lords. My lord, your lordship may kindly grant me 2 days time, my lords. I'll do the needful.
Land Council for the appellant in MFA 5244 of 2023, Sri Ashok and Patil seeks 2 days time to do the needful. Full stop. Time as prayed for is granted. Full stop. On doing the needful, office is directed to send notice to respondent number 3. List both the matters on 4th November.
Please.
One submission, serial number 49, my lord. Ashok and Patil has been company appeal, my lord. Kindly delete my name, my lord.
B. Pradeep, name may be deleted.
Because they filed company appeal, my lord.
File your wakalat. How can we delete your name? You follow the procedure.
Please, my lord.
45.
55. Yes.
Matter may be referred to Lok Adalat. I am per claimants.
I am for respond number 2, my lord.
45. Your good name, Mr. Council?
Baira Reddy GS.
Sri Baira Reddy, representing Srimati Kavita Hetsil and Council on record for the appellant, seeks to refer the matter to Lok Adalat for settlement. Hence, the matter is referred to Lok Adalat.
My lord, my name may be deleted in that case, my lord.
As Sri P. Pradeep is on record for respondent number 2, office is directed not to show the name of Sri D. Vijay Kumar in the cast list hereafter. Yes.
Much obliged.
Much obliged.
Court officer.
ಹೇಳಿ ಸರ್ ಹೇಳಿ
Serial number 42 ಇದೆಯಲ್ಲ
42 ನಾ ಇದೆ ಸರ್
ಓಕೆ ಸರ್ ಈಗ ನೆಕ್ಸ್ಟ್ ಎಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಈಗ
ನೆಕ್ಸ್ಟ್ ಒಂದು ಪಾಸ್ ಓವರ್ ಇದೆ ಆಮೇಲೆ ಅದೇ ಈಗ ಅರ್ಧ ಆಗಿದೆಯಲ್ಲ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್
ಓಕೆ
38
Court officer? Court officer?
ಹೇಳಿ
Serial number 65, 66 ಎರಡು ಇದೆಯಾ?
ಇದೆ ಸರ್ ಇದೆ
ಆಮೇಲೆ ಇನ್ನೊಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 44 ಇದೆಯಾ?
ಇದೆ ಸರ್.
ಓಕೆ, ರೆಡಿ.
Consider second petition, my lord. Then is the reassessment, my lord. Yes.
Could observe.
No, precisely because you have traveled United Nations Congress.
Sir, ಹೇಳಿ.
ಕೋರ್ಟ್ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
That I will not get it.
ಹಾ ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಸರ್ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆ. ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ನಾನು.
Okay, okay, okay.
It's a bit
ಎಷ್ಟು ಇದೆಯಲ್ಲ ಎಷ್ಟು ತಗೊಂಡ್ರ ಒಂದೇ ಇದೆ ಮಧ್ಯಾಹ್ನ ಅವ್ರು ಬರೋದಿಲ್ಲ.
Discontinuation.
Serial number 38, MV Maheshwarappa, D Pradeep for R2,
And for respond number 2, my lord. Third case.
38.2.
MFA 603/2022. Page number, internal page number 33, your lordship. MFA 603/2022. The age is about 50 years.
Page number
Page number, internal page number 33.
33, yes,
MUC number 2649/2018.
yes.
PW2, that is the petitioner Srimati K. Sunita, has contended that she was aged about 48 years at the time of accident. In order to prove age of the petitioner, PW2 has not produced any document, but on perusal of Exhibit P11, wound certificate, age of the petitioner is mentioned is 48 years. Hence, based on the above document, it is considered that the petitioner aged 48 years as on the date of accident. As per the Sarala Verma case, a proper multiply is 13. PW2 has contended that she was running a stationery shop and earning a sum of rupees 20,000 per month. In order to prove her income, she has not produced any document. Hence, it is just and proper to consider the 9,000, your lordship. 2017 is the accident. PW2 had sustained thoracic D11 and D12 compression fracture of right lateral malleolar fracture, for which she underwent posterior instrumentation and stabilization from thorax D9 and lumbar L2 with decompression, and right lateral malleolar fracture was treated conservatively. That is para number 35, Your Lordship. This has been corroborated by the contents of Exhibit P11 and P12, wound certificate and Exhibit P19 discharge summary issued by MS Ramaya Memorial Hospital, wherein she took treatment inpatient from 14/12/2017 to 23/12/2017. PWT has also produced Exhibit P13 medical bills to the tune of rupees 1,93,330. Exhibit P14 X-ray and Exhibit P45 bill receipt voucher along with inpatient medical bills. In the written argument, the first respondent counsel contended that the petitioner has produced 4 physiotherapy bills issued by Focus Diagnostic Center and amount of rupees 75,000. Serial number 53, it is stated home visit the physiotherapy on 26/3/2018 and charged 30,000. The bill issued 25/3/2000. Serial number 56, the bill issued 10/6/2000 as physiotherapy charges from 10/2/2018 to 10/6/2018 and bill number 289. In serial number 65, the bill issued on 10/8/2018 for physiotherapy charges from 10/8/2018 to 9/9/2018 and bill number is 290. Serial number 74, bill issued 10/10/2018 physiotherapy charges from 10/10/2018 to 9/11/2018 and the bill number 296, serial number so and so. Bill is issued different dates. Bill numbers are given serial wise. Some bills are issued before commencing treatment and some bills are issued after giving treatment. The bill 287 issued on 10/8/2000, but the bill number 278 issued on 10/10/2000, MEC 2650 in this case bill. So, Your Lordship, the in para number 37, the petitioner examined Dr. Mahesh M. Consultant, orthopedic and spine surgeon at MS Ramaya Hospital PW7 and got marked Exhibit P33 and P34. Case sheet X-ray PW7 has assessed total disability 90% for spine and overall disability 30% for the whole body. PW7 in the cross-examination deposed that he has treated the petitioner personally. She was operated spine fracture of and ankle was treated conservatively at the time of discharge. The condition of petitioner was stable. After discharge, she came from further treatment around 10 times. Now the fracture are united. If the oral evidence PW7 is perused, this accident was occurred 2017 and this PW7 has assessed PW disability in the year 2020. That means 3 years after the date of accident. His own admission in the chief examination reveals that fracture are united. Yes, this court considered the disability to an extent of 18% of the whole body. 30% whole body, 18% considered by the tribunal, Your Lordship. The award passed by the tribunal take into consideration the income is 9,000 and treatment and hospitalization 1,97,000 and nourishing food is 10,000, Your Lordship. Then the loss of earning during laid up period only 9,000 and the income taken 9,000, 18% disability. Non-pecuniary damages, pain and suffering 75,000 and loss of amenities 20,000, total 5,64,000, Your Lordship.
Yes.
As per income, my lord, there is a business they informed, but they have not produced any documents. Maybe notional income may be taken, my lord. Other aids, my lord, pain and suffering and amenities, loss of income during treatment period is reasonably granted, my lordship. 9,000 rupees has been granted. Later period maybe another 2 months, maybe my lordship may be granted. Disability, as per disability, my lordship, as per doctor only assessed 2017 accident. After the doctor has been examined, he is given 2020. He is given united fractures are united. In 18, tribunal has been taken 18% consider, my lord. That is correct, sir.
But the doctor says that 30% whole body already stated.
Loss of amenities may be reasonable, another my lordship may be granted. My lordship.
Yes. So after hearing both sides, we are of the view that the notional income has to be taken as 11,000, 25% future prospects, multiplier 13, disability 18%, it comes to rupees 3,86,100. And loss of income during laid up period, 8 months, 11,000.
8 months is a year said, my lordship, my lordship.
No, nature of treatment.
He underwent surgery for this.
Surgery.
10 days inpatient, my lordship. And fractures
Following
are
the
denied.
treatment.
Fracture of spine and she underwent surgery.
Please, my lord.
Yes, and food nourishment and other expenditure, it is increased from 10,000 to 15,000. Total enhancement 2,17,100.
Please, my lord.
Yes. Entitlement of site heating, that continuation which I was given, I gave dictation to Asif. Entitlement of the appellant in MFA 603 of 2021. Entitlement of compensation by the appellant in MFA so and so, who is the claimant in MVC 2649 of 2018. The undisputed facts of the case are as under. 1. The appellant sustained injuries in a road traffic accident that occurred on 14/12/2017. The appellant sustained thoracic D11 and D12 compression fracture and right lateral malleoli fracture, which are grievous in nature. Next, the appellant underwent a surgery for D9 to lumbar L2 compression. Next, the right lateral malleoli fracture was treated conservatively. Next, the appellant took treatment as inpatient for about 9 days. Next, though the appellant contended that by maintaining a stationary shop, she was earning rupees 20,000 per month, no evidence was produced before the tribunal to that effect. Next. Arguing the matter, learned counsel for the appellant, Sri M.V. Maheshwarappa, submits that the disability in respect of whole body as assessed by the tribunal itself is %, and that being the case, the award of rupees 9,000 towards loss of earnings during later period is highly irrational. Learned counsel also states that the tribunal took the notional income as rupees 9,000 and proceeded with awarding of amount of rupees 2,50,000 under the head loss of future earnings, and as the accident occurred in the year 2017, the figure adopted for notional income, that is rupees 11,000, ought to have been considered by the tribunal. Full stop. Sri Mallikarjun Reddy, representing respondent number 1, did not raise any objection for taking the notional income as rupees 11,000 per month. Full stop. Also, the said request appears justifiable. Full stop. Taking the notional income as rupees 11,000 per month, the appellant being aged about 48 years by the date of accident, adding 25% of the actual earnings towards future prospects, as per the decision of the Honorable Apex Court in Pranay Sethi's case, applying appropriate multiplier 13, and the permanent functional disability being 18%, loss of future earnings due to permanent physical disability is as under. Notional monthly income 11,000, annual income 12,000, 1,32,000, add 25% towards future prospects 1,65,000, apply appropriate multiplier 13, 21,45,000, loss of future earnings, permanent physical disability being 18%, 3,86,100. Next, the tribunal through the impugned order awarded a sum of rupees 2,53,000 only towards loss of future earnings. Thus, the enhancement in this regard will be 1,33,100 within brackets 3,86,100 minus 2,53,000. Next, having considered the nature of injuries sustained, more particularly to the spine, this court is of the view that the appellant would not have attended her normal pursuits at least for a period of 8 months. Thus, the loss of earnings during later period comes to rupees 88,000 within brackets 11,000 into 8. Full stop. The tribunal through the impugned order awarded a sum of rupees 9,000 only under the said head. Full stop. Thus, the enhancement will be 79,000 within brackets 88,000 minus 9,000. Full stop. Also, this court is of the view that the appellant is entitled to rupees 15,000 towards food, nourishment, and allied expenditure. Full stop. However, the tribunal awarded a sum of rupees 10,000 only under the said head. Full stop. Thus, the enhancement will be rupees 5,000. Full stop. Thus, the total amount which the appellant is entitled to, in addition to the sum that is awarded by the tribunal as compensation, is 2,17,100 within brackets 1,33,100 plus 79,000 plus 5,000. Full stop. Thus, this court considers that the appellant is entitled to a sum of rupees 2,17,100 in addition to the sum that is awarded by the tribunal as compensation. Yes, next matter.
Next one is page number 41, internal page. That is MEC 2650 for 2018, Channamma. Aged about 42 years, your lordship. And tailoring by profession. The 9,000 taken by the tribunal income. And your lordship, the 12% to the whole body is sufficient for calculation. But as per the doctor evidence stated that 20% of the whole body. Para number 49. Internal page number that is 45, para number. Petitioner Channamma has also adduced evidence. Dr. R. Kantaraj, orthopedic surgeon at General Hospital, Devanahalli, has PW8 and got marked exhibit P35 OPD card. P36 X-ray PW8 is assessed disability due to the compressive fracture of D5 and D6 with persistent pain in the back not responding at analysis is 20% of the whole body. But the tribunal taken in para number 51, your lordship, in the PW 8, in the cross-examination deposed that he has not treated the petitioner personally. Now the fractures are united, but compression in vertebra. Since the petitioner has sustained a spine fracture, particular limb disability cannot be assessed. Except this, all other suggestions are denied. If the oral evidence of PW8 is perused, this accident was occurred in the year 2017, and this PW8 is assessed disability in the year 2020. That means 3 years after the date of accident, and his own admissions in the chief examination reveals that compression fracture of D5 and D6. Hence, this court considered the disability to an extent of 12% to the whole body. The tribunal award of rupee treatment hospital 1,85,000, food and nourishment is 10,000, and 9,000 only for laid up period, your lordship. Then the taken income of 9,000 and 12% of the disability. Pain and suffering is 75,000. Amenities is 20,000 is on lawyer side. Totally 4,80,000, your lordship. The income taken by only 9,000, but as per the legal is 11,000.
She was treated conservatively.
Conservative. And para number 15 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. PW8 stated that petitioner had sustained a splenic injury and mild left phenothorax and hemothorax, multiple rib fracture. Para number 50.
Yes, Mr. Counsel.
Income they are telling tailoring, but 15,000 earning, but there is no document, my lordship. Maybe national income taken, my lordship. He is inpatient for 7 days, my lordship. Taken conservative treatment, my lordship. That pain and suffering already 75,000 rupees has been granted. That may be same, maybe retainer, my lordship. But laid up during laid up period, my lordship, 9,000 rupees has been given. Maybe 3 months, maybe my lordship may be granted, my lordship. Another amenities may be
Yes, notional income is taken as 11,000. So added 25% towards future prospects, disability being 12%. The increase would be 96,200. Loss of income during laid up period, it is taken for 5 months. The enhancement would be 46,000. So the total enhancement will be 1,42,200.
That's one submission, madam. In disability only 12%, my lordship.
12% only.
But the future prospect.
Already,
my lordship.
doctor has assessed.
My submission, my lordship. 12% is disability, my future prospect is not.
Yes, up to 12% only.
Please, my lord.
They're not taking.
Whole body
100%. Third. Next one. Entitlement of compensation by the appellant in MFA 656 of 2022. Who is the claimant in?
Channamma.
MVC 2650 of 2018. The undisputed facts of the case are as under. The appellant sustained injuries in an accident that occurred on 14/12/2017. Next, the appellant had splenic injury, multiple rib fractures, compression fracture of D5 and D6 vertebrae, fracture of right lamina, and fracture of left transverse process of D1 vertebral body. Next, the appellant was treated conservatively . However, as inpatient for a period of 7 days. Next. Learned counsel for the appellant, Sri M.V. Maheshwarappa, contends that the tribunal took the notional income as rupees 9,000 per month, which is erroneous. Learned counsel submits that as Taylor, the appellant was earning rupees 15,000 per month. However, as rightly contended by Sri Mallikarjun Reddy, no proof was produced before the court, before the tribunal, regarding the actual occupation and earnings of the appellant by the date of accident. However, learned counsel Mallikarjun Reddy did not deny the submission that is made by learned counsel for the appellant Sri M.V. Maheshwarappa that the notional income is required to be taken as rupees 11,000 per month for the relevant period, which the Karnataka State Legal Services Authority is doing. Also, the request made appears justifiable. Therefore, this court considers desirable to take the notional income of the appellant as rupees 11,000 per month by the date of accident. There is no denial of the fact that the appellant was aged about 42 years by the date of accident. Thus, 25% of the actual earnings are required to be added towards future prospects as per the decision of the Honorable Apex Court in Paralyzed case. Full stop. Also, the appropriate multiplier to be applied as per the decision of the Supreme Court of India in Sarla Verma's case is 14. Full stop. This court does not find any reason to interfere with the finding given by the tribunal that the permanent disability is 12% in respect of full body. Full stop. Thus, the loss of future earnings due to permanent physical disability is as under. Notional monthly income 11,000, annual income 1,32,000. Add 25% towards future prospects 1,65,000. Apply appropriate multiplier 14, 23 lakhs 10,000. Loss of future earnings. Sum of permanent physical disability being 12%, 2,77,000. The tribunal through the impugned order awarded a sum of rupees 1,81,000 only towards loss of future earnings on account of permanent physical disability. Thus, the enhancement will be 96,200. Within brackets, 2,77,200 minus 1,81,000. Next. Having considered the fact that the appellant sustained a number of grievous injuries for which she took treatment as inpatient, this court is of the view that the appellant would not have attended her normal pursuits at least for a period of 5 months. Thus, the loss of earnings during later period comes to rupees 55,000. Within brackets 11,000 into 5. However, the tribunal awarded a sum of rupees 9,000 only under the said head. Thus, the enhancement will be 46,000. Within brackets 55,000 minus 9,000. Thus, the total sum which the appellant is entitled to receive in addition to the sum that is awarded by the tribunal as compensation is 1,42,200. Within brackets 96,200 plus 46,000. Thus, the appellant is entitled to a sum of rupees 1,42,200 in addition to the sum that is awarded by the tribunal through the impugned order. Thus, in the light of the foregoing discussion, all the appeals are disposed of with the following orders. The following order. All the 4 appeals are allowed in part. I'll say blank sum, you fill up the blanks. The compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MVC so and so, is enhanced by so and so. Likewise 4. Next to 5th, next one. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition to the date of deposit. The respondent number 1 is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, the appellants in all the appeals are permitted to withdraw the deposited amount.
Much obliged.
और एक पेपर दिया है ना सुबह
Passover matter, serial number 16, Gurudev Prasad KT, Vidni Ravish.
Case of injuries.
Any objection for?
Sorry, case
delay?
of death, no, my lord. Interest may be,
Only 84 days.
oh, then it's sorry.
IA 1 of 2022 is filed seeking the court to condone the delay of 84 days in filing the appeal. heard Sri Gurudev Prasad Ketil and counsel for the petitioners, appellants, as well as Sri
I represent Mr. Binni. My name is Y.K. Sheshagiri Rao.
Y.K. Seshagiri Rao, learned counsel who appears on behalf of Sri Benny Ravish, learned counsel on record for respondent number 1. Gone through the contents of the affidavit given in support of the petition. Instead of having considered the ground urged, the delay as prayed for is condoned. Yes.
Case of death. Accident is dated 4/4/2019.
Who are the claimants?
Wife, two minor daughter and son, and mother of the deceased, 4 claimants. Deceased was raised for 36 years. He was a mason, para 14, 15.
He is Ravi Kumar. Deceased
Yes,
is
Ravi Kumar. $36 years. 15 multiplier properly applied, and income 9,000 has been considered. The mason, the accident is during 2019. Notional income 14,000 has to. %, future prospect.
So the notional income is 14,000.
14,000, 40% has to be added.
So deduction is 1/4.
1/4.
1/4.
Court also deducted 1/4.
Multiplier is 15.
15. And
Yes, Mr. Counsel.
Yes, my lord.
conventional rates.
Yes.
My lord, since the notional income for the year 2019, 14,000 has to be taken into consideration, that has to be modified. And as far as other heads are concerned, my lord, it is quite reasonable. That cannot be, I request your lordship not to disturb on this, maybe modified.
Yes. So we have taken the notional income as 14,000, added 40% towards future prospects, deducted 1/4, and applied appropriate multiplier 15.
15,
It comes to rupees 26 lakhs
46,000.
And 15,000 towards funeral expenses, 15,000 towards loss of estate, 40,000 towards loss of
Yes,
spousal
ma'am.
consortium, 40,000 towards loss of parental consortium, and 40,000 towards loss of filial consortium. Total 27 lakhs 96,000. Third, Sri Gurudev Prasad KT, then counsel for the appellants, and Sri Y.K. Seshagiri Rao, learned counsel who represents Sri Benny Ravish Chandrasekhar, learned counsel on record for respondent number 1 insurance company. Next. Disputing the validity of the order that is rendered by the Motor Accidents Claims Tribunal Bangalore in MVC 2389 of 2019, dated 12/11/2019, the claimants therein are before this court by way of appeal. Next, Sri Gurudev Prasad KT for appellants submits that the first appellant is the wife, the appellants 2 and 3 are the minor children, and appellant number 4 is the mother of the deceased Ravi Kumar, who died in a road traffic accident that occurred in the year 2019. The deceased Ravi Kumar, within brackets, hereinafter they refer to as the deceased for brevity, was earning ₹1,000 per day as a mason and was contributing his entire earnings towards the welfare of the appellants. The appellants lost the only earning member in the family. However, though the appellants projected a claim for rupees 30 lakhs, the tribunal through the impugned order awarded a sum of rupees 17,71,000 only as compensation, and therefore the appellants are before this court. Learned counsel also states that the accident occurred in the year 2019, and for the relevant period, the Karnataka State Legal Services Authority is taking the notional income as rupees 14,000 per month for settlement of claims, and at least set figure should have been considered by the tribunal. Learned counsel also states that the amount awarded as compensation under other heads is also grossly low. On the other hand, Sri On the other hand, Sri Y.K. Seshagiri Rao, representing respondent number 1 insurance company, states that the amount awarded as compensation by the tribunal is reasonable. However, learned counsel did not raise any objection for taking the notional income as rupees 11,000 or 14,000 per month as sought for by the learned counsel for the appellants. Also, the said request is reasonable. Next, therefore, taking the notional income as rupees 14,000 per month, comma, the adding 40% of the actual earnings towards future prospects, comma, the age of the deceased being 36 years by the date of accident, comma, deducting 1/4 of the earnings towards personal and living expenses which the deceased would have incurred for himself had he been alive, and applying the appropriate multiplier 15 as per the decision of the Honorable Apex Court in Sarla Verma's case, comma, the loss of dependency is calculated as under. Notional monthly income 14,000, annual income 1,68,000. Add 40% towards future prospects, 2,35,200. Deduct 1/4 of the actual earnings towards personal and living expenses, 1,76,400. Apply appropriate multiplier 15, 26,46,000. Thus, the loss of dependency, thus the compensation which the appellants are entitled to under the head loss of dependency comes to rupees 26,46,000. Together with the said amount, comma, the appellants are entitled to rupees 15,000 towards funeral expenses and 15,000 towards loss of estate. The first appellant, being the wife of the deceased, is entitled to rupees 40,000 towards loss of spousal consortium. The appellants 2 and 3, being the children of the deceased, are entitled to rupees 40,000 towards loss of parental consortium. The fourth appellant, being the mother of the deceased, is entitled to rupees 40,000 towards loss of filial consortium. Thus, the compensation which the appellants are entitled to under different heads is as under. Loss of dependency 26,46,000. Funeral expenses 15,000. Loss of estate 15,000. Loss of spousal consortium 40,000. Loss of parental consortium 40,000. Loss of filial consortium 40,000. 27,96,000. We'll stop. In the light of the foregoing discussion, comma, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 2389 of 2019, dated 12/11/2019, is enhanced from 17,71,000 to 27,96,000. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Respondent number 1 is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, out of the enhanced sum, comma, the appellants are entitled to equal share. Next, appellants 1 and 4 are permitted to withdraw their respective shares immediately. Next, the amount that fell to the share of appellants 2 and 3 shall be, along with interest, shall be kept in fixed deposit in any nationalized bank till they attain the age of majority. full stop. On their attaining the age of majority, they are entitled to withdraw the same along with accrued interest.
Serial number 39. SC Rishabhendraya. Manjana MS, respondent.
Respond number 1.
Yes, my lord. Submit that one more appeal has been filed by him on today.
I have filed a appeal for enhancement in MUC number, in MFA number 5514/2023, Lordship. Kindly list the matter along with this.
39. You are Mr.
Respond number 1 and 2, MS Manjan.
Manjana. Sri
MS.
Manjana MS, Land Council for Respondents 1 and 2 submits that Respondents 1 and 2 have preferred another appeal by the MFA so and so. Stop seeks to list both the matters on the same day. Full stop. In the light of the submission thus made, register to verify and to list the present matter along with the MFA so and so on 21st October.
Serial number 40, adjourn. 41, Pradeep B. Respondent served.
Insurance company challenging liability, my lord. You have deposited before tribunal, my lordship. Press 2 weeks time, my lordship, I will produce acknowledgement, my lord, deposited.
Land Council Sri Mallikarjun Reddy, representing Sri Pradeep B. Land Council on record for the appellant submits that 50% of the award amount as ordered was deposited before the consent tribunal. Full stop. Seeks time for 2 weeks to file proof to that effect. Time as prayed for is granted. Stand over to 28th October.
28th?
28 October.
Please, my lord.
Serial number 42, Gurudev Prasad, KT, SV Hegde Mulkhan. Sir, SV Hegde Mulkhan, serial number 42.
Heard Sri Gurudev Prasad KT, Land Council for the appellant. No representation on respondent side on call. Admit. Records are required.
Records not necessary.
Admit, list the matter under the caption final hearing on 30th September.
Serial number 43. K. Prasanna Shetty. R2 served.
For the appellant, my lord. My lord, we have served the notice, my lord, but still they haven't filed the wakalat, my lord.
Where is the acknowledgement of having served?
Submitted, my lord.
See your good name, Mr. Council.
Bharat Pujari.
Heard Sri Bharat Pujari, Land Council who represents Sri KT Prasad, Prasanna Shetty, Land Council on record for the appellant. Admit, list the matter under the caption final hearing on 21st October.
My lords, do we need to serve one more notice?
No, not required.
Blessed.
Serial number 44. D. Vijay Kumar, Amshit Hegde for respondent.
Respondent. Respond number 1. I have filed application for release of the deposited 50% amount.
Where is the appellant?
D. Vijay Kumar, serial number 44.
No representation on appellant side on call. On the other hand, Sri
MS Manjana on behalf of
the MS Manjana representing Sri Amshit Hegde,
Amit Hegde HS.
Amit Hegde, Land Council on Land Council for respondent number 1. Amshit Hegde, Land Council on record for the respondent number 1, projects urgency. To give fair opportunity to the appellant to pursue the matter, list on 22nd October.
Respect.
Till number 45 adjourn, 46 Janardhan Reddy, Bopanna B for respondent.
And for respondent number 2, madam. Case we not served, madam. That's fine. Two copies.
Through court itself, sir, served, my lordship.
Copy banana.
I'll furnish one set, no problem with that. Because after the serving of the notice only, court notice only, they have filed a claimant's appeal also. I'll furnish one more set, my lord.
We'll admit all the appeals, Mr. Counsel.
Yes, my lordship.
Both petitions.
What is this?
My lordship, I've already deposited in meanwhile,
So you are appearing in other two appeals, Satish,
claimant's appeal, my lord, see there. Company,
representing whom?
R2, respondent number 2, madam. Ashmikant.
Who is respondent number 2? Which council you are representing?
Respondent number 2, madam.
What is the name of the council?
Lakshmikant K.
is my insured, my lordship. Notice was served through court only, my lordship. In spite of that also, he is asking also, I'll furnish the copies one more set also.
Await records from the consent tribunal. List on 21st October.
Serial number 47 to 52 adjourn. 53 Vasant Kumar KM,
For the appellant in this case,
Lata Prasad for R2.
case of injury, my lord.
Yes, where is the other side council?
53
Lata Prasad, Wakalat not filed. You are Mr. Vasant Kumar.
Please, I am the Vasant.
Sri Vasant Kumar KM for appellant is present before this court physically. Full stop. However, there is no representation on respondent side on call. Full stop. Srimati Lata Prasad was directed to accept notice for respondent number 2 on 18/8/2023. Full stop. Wakalat is not filed till now. Full stop. Also, there is no representation. Full stop. Therefore, issue notice to respondent number 2 on furnishing the requisites. List on 28th October.
My records may be called.
Call for the records from the consent tribunal in the meantime.
54, 55 adjourn. Serial number 56 Malika MD Rekha, BS Krishna for R2. Serial number 56
No representation on either side on call. To give fair opportunity, list on 15th October.
Serial number 57 AN Krishna Swami, Gopal Krishna N for respondent.
My lord, I represent Mr. Krishna Swami. He seeks for a week's time. I was told he has deposited the 50% of the amount before the tribunal.
Sri YN Seshagiri.
Why came in? YK Sheshagiri Rao.
Seshagiri Rao representing Sri N Krishna Swami submits that amount as ordered was deposited. Full stop. Seeks time to file acknowledgement. Time for a week is granted. No representation on respondents.
My lord, Krishna Swami is my colleague.
You are for the respondent.
He requested me, my lord.
Remove that. Remove that. No representation on appellant side on call. Acknowledgement of having deposited 50% of the above amount is not filed yet. Full stop. To give fair opportunity, time for a week is granted. Full stop. List on 21st October.
Thank you. My lord, time, date.
21st October.
Much.
Serial number 58, adjourn. 59, Kavita HC, Pradeep B for R2.
I am for respond number 2, my lord.
No representation on appellant side on call. Sri Mallikarjun Reddy representing Sri Pradeep B. For respondent number 2 is present before this court physically. Instead to give fair opportunity to the appellant to pursue the matter list on 15th October.
Please, my lord.
Serial numbers 60 to 63, adjourn. 64, Pawan Chandra Shetty, C. Shankar Reddy for respondent. Serial number 64,
No representation on either side on call. To give fair opportunity list on 25th November.
serial number 65, final hearing, D. Vijay Kumar, Hanumantappa for R1. Serial number 65,
No representation on either side on call. In both the appeals. There was no representation on 1/8/2024 and also on 13/8/2024. Full stop. Therefore, list both the matters on 19/9 under the caption for dismissal.
serial number 66, D. Vijay Kumar, Anuradha Aras for respondent.
I appear for the respondent, please, Your Honor.
Yes. No
Last
representation.
occasion also,
No representation on appellant side on call. Srimati Anuradha As representing the respondent is present before this court physically. Full stop. There was no representation even on 13/8. Full stop. Therefore, list the matter on 25/9 under the caption for dismissal.
Serial number 67,
Sorry, madam.
66. Yes.
Ready, madam.
Just, can it be passed over? Just I'll glance the papers and make submission.
We'll call at the end of the list. Next.
Please, madam.
We'll call at the end of the list.
also.
There are few matters. After those matters, we'll call.
Please.
Serial number 67, Srinivas Ayya A. K.N. Srinivas for R2.
No representation on either side on call. To give fair opportunity list on 15th October.
Serial number 68, Adish NR,
My lord, I am for the appellant, my lords.
Nanda KS.
I am for respondent number 2, my lord.
So the claimant, the claim petition is dismissed, my lords. And also if praying my lords to call for TCR, my lords.
At request of Sri
Telecast.
Shreyas N, my lord.
states in Land Council who represents Sri Harish NR Land Council on record for the appellant. Call for the records from the consent tribunal. List on 21st October.
Please, my lord.
Grateful.
Serial number 69, Vijay Kumar T, BC Shivannegowda.
No representation on either side on call. There was no representation even on 31/8. Hence, list the matter on 39 under the caption for dismissal. Mr. Vijay Kumar, if you want time, we'll have it day after tomorrow.
66.
Yes. Record it. Record.
Not this appeal is by the BMTC challenging the involvement of the vehicle in the accident
Yes.
and also rational negligent act on the part of the driver of the bus and quantum of compensation. Well, the alleged accident has taken place on 15/4/2017 at about 10 p.m. AM. Lord, according to the petitioner, my lord, he was traveling. The lady, that girl was traveling in the said bus, and when the bus suddenly applied the brake, she fell down from the bus. Thereby, she sustained injury and sustained the injury. She has filed the claim petition. Or the complaint was given on the next day by the father of the petitioner, who was not at the place of accident and he has not at all seen it. There is no mention at what time she was traveling in the bus, either in the complaint or in the police records or even in the claim petition, and also this. Nowhere it is mentioned what time she was traveling from which place to which place and in which seat she was sitting or standing in the bus and how she could fall down. That too when she was traveling along with her classmates. Definitely, my lord, her classmates would have noted the time, vehicle number, and also the place of accident.
Records.
And they should have immediately given complaint to the police. There is no way her own classmates, friends who are traveling along with her has not given the complaint. And she is aged about 15 years, but they have stated as 19 years. But as per school records, it is 15 years. She is a minor girl. And my lord, in spite of denial of the total involvement of the vehicle in the accident, my lord, except the evidence of PW1, that is Father Krishnamurthy, they have not examined the claimant. And to know the injury, what type of injury, what is the difficulty, what are the disability and other thing, tribunal should see the claimant to assess the injury, damage and disability. On the basis of the evidence given by the father, my lord, in case of death, my lord, he can give evidence. But not in case of injury. There is a judgment of our own High Court. If the claimant is not examined before the tribunal or not even examined before the tribunal, so the petition itself is not pensionable and the claimant is not entitled for compensation. Because behind the back of the petitioner, whatever the father says, whatever the doctor says, court has to believe it. Many times, my lord, the doctor medical documents is full of exaggeration. To compare with the documents, evidence, and also the physical verification of the witness, my lord, the presence of the petition is necessary. Therefore, my lord, here, my lord, the tribunal, my lord, has awarded huge compensation of rupees 11,90,536 rupees. My lord, towards pain and suffering, my lord, 40,000. Medical expenses 3,80,536. Food nourishment and nourishment charges 7,200. Conveyance 10,000. And discomfort inconvenience 10,000. My lord, loss of future income, my lord, 7,12,000 is awarded to a school going girl. My lord, according to the age, my lord, as per Exhibit P, my lord, only 15 years.
Settle the matter.
She is studying in 10th standard.
We have got nothing, please,
Settle
your
the
lordship.
matter. Because this is no, this much of amount.
Impossible, my lord. It's very much on the higher side.
May I make my submission, please? I have got nothing to settle. I am agreeable for any settlement, please, your lordship. That is one thing. Second thing is there was a submission made that she is 15 years school going girl. Yes, I do not dispute that also. There was a submission that there was a total denial of the vehicle involved in the accident, which I deny. Because in their objection statement itself, they have agreed that the vehicle was involved in the accident. Yes, there is a mistake. That is, instead of E, instead of F, E is mentioned in the petition. Taking advantage of that, in the appeal, they're trying to say that that is not the vehicle involved in the accident. Because objection statement, they have clearly stated, they admit the accident, they admit the vehicle. They do not deny that she was not traveling in the vehicle. All these are admissions, please, your lordship.
Mr. Vijay Kumar, how much can
My
be
lord.
reduced?
My lord, because
Aspect
at
of
the age of
negligence
the
will not-
girl is 15 years because she is a 10th standard student. My lord, my humble submission to your lordship is, my lord, compensation towards future loss of income, my lord, does not arise.
Global sum you take.
Global sum amount, I leave to your lordship, my lord, whatever the reasonable compensation,
We-
I am agreeable, my lord.
My lords, my only submission is she is totally paralyzed. And considering that she is a female child who's totally paralyzed and her education stopped at SSLC because she could not continue her education also because the documents clearly show that she had head injury. Till date, she is paralyzed. Considering that, I have got nothing, please, your lordship, because the family is in a very pathetic condition, not that they are even middle class people.
My lord, kindly
My
see the
learned
cost
friend
title, my
feels
lord.
that
My lord, kindly see the cost title, my lord, of the claim petition. If she is really paralyzed,
I can keep her present before the court. The trial court could see the petitioner. Even here, the court can see the petitioner. I can keep her present tomorrow itself.
Yes,
my lord, my humble submission, my lord, out of 7,20,000, what, 7 lakh and add, my lord, your last may make it instead of future loss of income, my lord. Make it, my lord, 3 lakh rupees lump sum.
So much reduction. This is, the tribunal has awarded 11,90,536. So we'll make it 10 lakhs.
My only I'm seeking reduction only in respect of future loss of income.
Globally,
My lord, even
we'll reduce it by 1 lakh.
my lord, assuming, my lord, because why I'm making this submission is even assuming that if your lordship were to take up to 30% disability, Mallikarjun case is applicable.
Yes, yes.
In case of Mallikarjun case, my lord, all other things will dissolve and only 3 lakh will be awarded. Here, my lord, I am considering for 3 lakh plus other.
Mr. Counsel, subsequent decision is there. Both the parties agree, we'll make it at 10 lakhs. 11,90,000 means 1,90,000 will be reduced.
Lord, make it 8 lakh, my lord. 8 lakh.
My lords, I have got nothing to add, please, your lordship. I only leave it to the council and
Because-
the court.
Yeah.
Because I know
I-
what pathetic condition the girl is.
Lord, make it 9
And
lakh, 9 lakh, my lord, close it. Please, my
I leave it to the court, please, your lordship.
because there is a lot of exaggeration and other things.
We'll not
Because,
discuss
my lord, if some, your Lordship may kindly appreciate, if really somebody fell down from the, that to a girl, school girl along with other classmates fell down from the bus, my lord, the driver of the bus will not move the place from the accident. Even the passenger in the bus will not allow the driver of the bus to move from the place of accident. And also the public at the place of accident will not move. Here, my lord, I don't want to say, it is a false implication. Therefore, my lord,
We'll not go into the.
deep regarding negligence aspect, my lord, your last may make it 9 lakh rupees. And
Sri D.
regarding
Vijay
interest, my lord, one just I will say 6% interest.
Yes. Heard
Similar
Sri
as
D.
award.
Vijay Kumar.
9% interest is the 6%.
6%.
Please, ma'am.
Heard Sri D. Vijay Kumar, Land Council
Okay,
for the
madam.
appellant, as well as Srimati
Anuradha Aras.
Anuradha, Land Council, who represents the respondent, Climant. Full stop. Challenging this appeal is the order that is rendered by the Motor Accidents Claims Tribunal, Bangalore, in MEC 6031 of 2017, dated 17/9/2021. Full stop. Land Council Sri D. Vijay Kumar submitted that the appeal is filed challenging the exorbitant amount that is awarded as compensation by the tribunal for the alleged injuries sustained by a girl aged about 15 years by the date of accident. Full stop. Land Council submits that the tribunal awarded a sum of rupees 7,12,800 towards loss of future earnings.
That, my lord, taking into 30% as a disability. But, my lord, when it takes 30% disability, should go by the Mallikarjun judgment. That has not been followed.
Subsequent
As per-
decision is there. The Supreme Court did not stop with Mallikarjun case. Subsequent decision is there where some modification is given.
Please, my lord.
What did
Because
you write?
when we filed the appeal on that day, this is the situation. And
7,12,800 towards loss of future earnings. That too for a girl aged about 15 years and a school-going child, which is unjustifiable. Full stop. Land Council submits that the amount awarded as compensation under all other heads is also grossly high. Is also exorbitant. Full stop. Srimati Anuradha Urs, Land Council for the respondent, submits that the condition of the respondent claimant is pathetic and she is still bedridden. Full stop. Land Council states that, however, as the appeal is pending since a long time, the court may reduce the compensation to certain extent and pass appropriate orders. Full stop. It is not in dispute that the appellant, the respondent claimant sustained grievous injuries due to the accident and took treatment as inpatient. Full stop. The fact that the respondent claimant sustained traumatic brain injury and underwent surgery is borne by record. Full stop. However, considering the fact of absence of any substantive proof with regard to the alleged loss of future earnings to the extent of 30% as observed by the tribunal, this court is of the view that the compensation awarded is liable to be reduced as prayed for. Full stop. As agreed upon by Sri Vijay Kumar Land Council for the appellant and Srimati Anurag, more particularly Srimati
My lord, my
Anurag.
agreement is before the court, not on record. It's not be on record.
Srimati
Of course, my
Anurag
lord, BMTC will agree whatever I take a decision,
MD,
but still,
for the proposal made by the court,
please, like that.
date of the agreement by,
Yes, ma'am.
by Sri Vijay Kumar and Srimati Anudana Woods MD, Land Counsel for the respondent, that the justifiable sum which can be awarded as compensation is rupees 9 lakhs. Comma, the appeal is disposed of accordingly. Full stop. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 6031 of 2017 dated 17/9/2021 is reduced from 11,90,536 to 9 lakhs. Full stop. The sum awarded shall carry interest at the rate of 9% per annum.
That's 6%.
6% per annum from the date of petition till the date of deposit. The appellant is directed to deposit the entire sum within a period of 8 weeks from the date of receipt of copy of this order. Full stop. The award of the tribunal in all other aspects holds good.
Amount in deposit may be transferred to the
Amount, if
tribunal.
any, in deposit be transmitted along with the consent record to the tribunal immediately.
Much obliged.
Where were you, Mr. Vijay Kumar? When your matters were called, you were not there. Yes.